Okay. Mr. Sharp?
So I agree with what they want to take out, and then on page 63, just so everyone's on the same page, 63 seems like a discussion that Kenneth Copeland is having about information he got about Jeffery Williams wanting to hurt him or set him up. Is that correct?
Yeah, so the next part that we do want in is page 62, line 23 through page 70, line 16.
To page what? I'm sorry, ma'am.
Through page 70, line 16. Oh, excuse me, they went out, but we were like in, sorry. Or, I believe they went out.
That's pretty much the top.
And I'm sorry. They went out page 62, line 23 through page 70, line 16. We will be objecting to that.
Okay, 70s. Let me just.
So the state wants to play from 63, page 63, line 23 to page 70, line 16?
Page 62, line 23 through page 70, line 16.
All right, and the defense doesn't want to have that played.
Your Honor, if I could just confirm. I think the defense is going to object to that, so we can just play that.
Sure. Okay. Can you,
Yes.
Okay, all right. What
It'll be
video period is it from?
Yes, right. It's going to be from 10:19. Probably more around. I'm going to start it at 50, but I think it's more like 10:19:58 to 10:25:22.
All right. Whenever you're ready.
What that got to do with why is Thug in the mix like he's a dime around this motherfucker like and that's what first told me who told me like it was a girl. You know what I mean? I put up his baby for it. It was on the day I put up his baby for it. I had baby Sunday. I put up his baby for it Sunday. It was Sunday. I put up his baby for it. Me and my baby and my little partner Kino and me, Kino, the baby, and BJ, CJ. So we pull up. Everybody got color, they don't live with that type. But me, they went Kino white. Me, CJ white. Me, CJ white, the baby. Me, CJ white. Sounds like not important. Yeah, but see, Battery got in the color, she was like, hey bro, I'm gonna tell you something, don't say nothing. You know what I mean? I'm like, what's up? She's like, go up there, this and that. I'm like, no, what is it? What you mean? She like, I didn't don't trust this nigga, bro. I mean, they really trying to set you up. That's why every time I got in jail, someone got shot up. Like, what the hell? These niggas keep shooting shit up for when I get out. So you think it's thugs them shooting at your people? Nah. I know it ain't thugs them because they got these niggas thinking it's me. See, I had seen Monte. I seen him What did you want to say? Yeah. Okay. I seen him the other day, like day before yesterday. I seen him yesterday morning. I went to the graveyard. When I seen him, he was at my cousin's house. When I heard what happened, I was looking for him and was like, damn, bro, we going up there. Right. So I'm like, damn, bro. Y'all ain't gonna let him man Yak, brother, you know? Nope. You say you grew up with him? I didn't know his first name, Wesley. I don't know his last name. No, but when I tell like, damn, bro, motherfucker told me that Thug plan on killing me, bro. Like, hell nah, man, I ain't never heard it. Dude, he denied. I'm like, come on, bro. Person would never say, because this was murder, I don't talk to the police too much. Mm-hmm. You know what I'm saying? So he get nervous. Thug get nervous. Yeah. But I'm saying, why is Thug get nervous if he has nothing to do with anything? Because they obviously look at you as disposable. Oh, see, y'all didn't hear them say my name. They said me and Thug. That's like he's saying. But I'm saying like I didn't have no parts to it. And I can't see how scared I was when he happened. You feel what I'm saying? Hey, but so he felt like you would tell something. Yeah. Okay, what is there to tell? Huh? What is there to tell? This what I'm telling you. This what he keeps saying. This what I mean. I'm asking like, what? You know what I mean? But see, with the murder, I don't know what you mean. No, I'm trying to explain. With the murder, I act like I never heard that. You know what I'm saying? I never told Dina none of it. Period. So I just kept it to myself. So, once again, why is he, if Thug has nothing to do with it, if Thug has nothing to he don't got nothing to do with it. What I'm saying is, he got to have something to do with it. All this shit going on. And which means he has to have told you something if he's nervous about you. He's speaking to us. He's not listening. I'm listening to you. He's not talking to me, period. He's not talking to you, period, for a reason, correct? Yeah. I think it's because you're talking to us. Yes. He not thinking I'm telling y'all that. He just saying I'm talking to the police a lot. Because he heard the conversation in the police had.
Basically, what she's saying is, listen, it's almost like she look at you as the person that can bring him down. So therefore, by eliminating you, he eliminated his problem. That's what she's saying.
This what I'm telling y'all. When police detective called, it was a lady. I answered the phone in front of him.
Which case was it?
See, they weren't even saying no case. They just like, now this is about my house getting shut up. You know what I mean?
Right.
So when he saw it, he's like, damn, I need to talk to the police. See, he was telling folks different lies. I mean, he told the D I'm making the D clean never. He's mad at me because he gave me $50,000 and ain't know what to do with it. What you mean you know what to do with it? Why we need $50,000? Well, this nigga never gave me, you know how much money he ever gave me at one time? $1,000. You know what I mean? That ain't what you said last time you interviewed when y'all was at the club when they stunted on you and you came. I get him with a bag. How you give it back if you some money? Nah, that's wrong. Here's money. You getting I'm getting confused. Yeah, you getting screwed wrong. You gotta let it get paid. Okay. That's how you give me the money to bless you. If it's like this is showing down.
Then let me get that back.
But the money he give me, the key, is like $1,000. Get the fuck out of it. I don't believe it. I don't have my own car. That's the first time I ever got my car. I don't have a car. So what have you done for Thug? Nothing. That's on my mama's soul. You never committed a crime for Thug. I never did none of that for him. So why would he say, look against his schedule? No. That song got the song about little boy you put up on your top at your 9. Okay.
And we end at 10:25:23.
All right.
I assume the next line was Shannon is the shooter. I assume we're taking that out.
Yes.
Okay.
Okay, Mr. Shard or Mr. Steele or anyone else, you want to tell me why it is that you believe that period should, from page 62, line 23 to page 70, line 16 or thereabouts should be, omitted?
I do, Your Honor.
Okay, go right ahead, sir.
That section that are in those transcript pages and what you just listened to have Detective Dennis as well as Detective Gaither injecting their beliefs and thoughts. And by that, I mean Detective Dennis and Detective Gaither told Mr. Copeland that they do not believe him when he claimed that Jeffrey has not given him any money except for $1,000, and that they did not believe him when Mr. Copeland said that he's never committed a crime for Mr. Williams. I also object to the detective. It's both of them. It's first Detective Gaither, then Detective Dennis, saying that their belief is of summarizing what Mr. Copeland was trying to say is that Mr. Williams looks at Mr. Copeland. Mr. Copeland is bringing Jeffrey down or Mr. Williams down, quote unquote, and therefore they latch on to Mr. Copeland when he said that he heard that Jeffrey put a contract on his life or would have him killed. So that's why I'm objecting. I asked Mr. Sharp to include that. I appreciate it. And that's my basis. I believe that I would have a confrontation right. These are thoughts of the detectives that they couldn't testify to themselves in front of the jury because it would be their own speculation. So I'd like that removed. And Mr. Copeland hearsay saying that he heard that Mr. Williams would have him killed. So those are the reasons that those areas are flagged.
All right, sir. Mr. Shard, anything else?
No, I'll just about Mr. Steele's objections to that time period.
Okay, all right. State?
Thank you, Your Honor. This portion is relevant for a number of different reasons. This portion is relevant for a number of different reasons. First, starting on page 62, they're getting into a conversation to understand why he is concerned about the fact that he's talking to the police. Where does that concern come from? And he begins to explain a number of different things. First thing he explains is how he learned of the fact that he thought Mr. Williams wanted to harm him. And it's not so much what Valerie told him, but what he did with that information. Even on page 63, he doesn't go into detail about what Valerie told him. She said, I think Valerie told him he's trying to set you up. What he does with that information is he approaches Yak, which is one of our co-defendants sitting in the courtroom today, Mr. Kendrick, to ask him about what he had just learned. And so we believe that this portion, whatever Valerie told him, isn't being offered for the truth of the matter asserted, but the effect on the listener, which is after hearing this, he went and asked Mr. Kendrick about whatever it is that Valerie told him. And then Mr. Kendrick then assured him that that wasn't true, that he isn't trying to harm him. And the jurors should be able to ascertain whether or not they believe that this interaction occurred. Then he goes into why there was a concern with Mr. Williams, and that's about him going to talk to the police too much. And he goes into talking about an incident in which Mr. Williams was present when one of the police officers called his phone. And so that isn't hearsay, that's personal knowledge of this event that took place that at some point in time, when Mr. Copeland was in the presence of Mr. Williams, a police officer called him, and he's explaining.
Called him being who?
Called Mr. Copeland. So
Okay.
Mr. Williams and Mr. Copeland are present with each other. A police officer called Mr. Copeland in his presence. And he's telling the police officers his understanding of what that interaction meant to him. And again, that is relevant as to why he was concerned about why he thought Mr. Williams wanted to harm him. Again, because he was talking to the police too much.
Let me just ask you, just to make it, see if it's clear in my mind. Are you saying that the officer called Copeland and Mr. Williams happened to be present for the phone call?
Yes.
Okay, and that's reflected, at least a portion of it, from what pages?
That is. Starting at page 67. Which is line 16.
Madam, do you need some cleanup?
Yes.
Here you go.
Page 16, line 60, page 67, line 16 is where he begins.
Okay, and where does that end?
And it ends on page 68. Line 9.
Okay.
And that's where he says, I'm telling y'all that. He's just saying, I'm talking to the police a lot because he heard the conversation me and the police had. And then he goes in to explain when that occurred. And then it goes into further, they ask him about whether or not Mr. Williams has ever given him money. And he says, no, he's only giving me $1,000 to keep. He's giving me money to flash, but not any money, not any additional money, because they're asking whether or not he's paid for him to do anything. And I think that that's relevant for whatever the jury determines that to be, whether or not they think Mr. Williams is or is not paying him to do anything do anything on behalf of him. And then he goes in, they begin to ask him, why are you mentioning his songs? If you're not doing anything for him, why are you mentioning his songs? Why does he say those things? And they're trying to get an understanding from Copeland, and really trying to challenge his veracity and what he's telling them, Your Honor. And I think that is important because, again, Mr. Steele's argument has been recently that the police just took everything that Mr. Copeland said and just ran with it without trying to verify it, without trying to test his veracity. And I think this shows that the police weren't just taking everything that Mr. Copeland was saying. They were challenging him on particular portions of the information that he was giving them. And I think that this goes to show a number of different things, the relationship between Mr. Copeland and Mr. Williams at the time of the interview that occurred. 2, to show that the investigators were not just taking what Mr. Copeland said as fact, but trying to test what he was saying, trying to clarify anything that they didn't think that they weren't sure of. And I think that is important for the jurors to be able to see the question that they're asking him and the answers that Mr. Copeland is giving, but then to determine how the investigation actually occurred, which is something that Mr. Steele has harped on, is that this investigation was not a full investigation, not a complete investigation. And so for those reasons, I think that this particular section is important and relevant to keeping.
Mr. Weinstein, you wish to be heard since your client's mentioned in this at all?
No, Your Honor.
Okay, all right.
I'll just adopt what's already been said.
All right, sir. Okay. Anyone else? Mr. Steele, you have something?
Follow up.
Yeah, go ahead, sir.
I also invoke 24-4-403 on the prejudice side about Mr. Williams supposedly having someone killed. I do not object if the state were to ask Mr. Copeland. I wouldn't object. Was there a time that law enforcement officers called your cell phone or your telephone, Mr. Williams was with you? Tell us what occurred then. Did Mr. Williams react? But they didn't lay that predicate. So I don't believe, again, like I maintain my objection, that they can just play a sequence on June 10th, 2015 and expect there to be just admissible. So I'm objecting to that first predicate. Second part is, I don't object if Mr. Copeland testifies, or if there's a prior inconsistent statement, if he testifies differently, that Mr. Williams was present when the police called. I'm not objecting to that. What I'm objecting to is law enforcement saying, that's not true. I don't believe you, that Jeffery Williams didn't give you money and that you never committed a crime for Jeffery. And for the state to say, oh, this shows the pushback of the police. It doesn't show the pushback of the police. To me, this shows that law enforcement has their theory and they're donating their theory onto the brain of Mr. Copeland. So I'm objecting to that because it doesn't show anything. You know, if law enforcement went out and we have reports, we have video, audio interviews, we have other witness statements, and they said, hey, we corroborated with X, Y, and Z that Jeffery Williams put a hit on this man, or that Jeffery Williams gave Mr. Copeland money to commit a crime. That's real corroboration. But this is not corroboration. This is the police telling the man over and over. It's what he testified to.
Hey, Your Honor.
Hold on, he's not finished.
I was lying to the police to get the target off of me. Anything I can do. So I'm not agreeing that the police can then just say through an out-of-court statement, we don't believe you. I think that the jury doesn't get to determine to hear that on what Detective Gaither and Detective Dennis say, because it is irrelevant.
But let me interrupt you just for a second. Isn't that part of the way the investigation occurred? And isn't that what you're also claiming is that their method of investigation is not good? I mean, or not as full or proper, and I'm sure you made that argument and you're going to ask that on cross, but isn't that the same kind of first part of the equation?
Well, if I open the door, maybe you change your ruling, if your ruling is in favor of Mr. Williams. But no, this is all the state's doing. The state asked you, you agreed that they could get into without giving us any reports, any statements.
Remember, there's no reports. There's no reports. You've asked me that you've made that statement many times. That's what your assertion is. There's no reports. There's no expert reports or anything like that. This is just their investigation, correct? And I know you have some consternation about that. And I know you can follow up on that too. So,
but their investigation became, don't tell me what was said, but did you investigate this? And as part of your investigation, what did you find? Well, we found out that Jeffery Williams is in charge of this criminal street gang. To me, that was a total violation of every reason we come to court. But the state can now put it on me and say, well, Mr. Steele is challenging the way that they did their investigation. When I cross-examine the witness, maybe it'll change. I haven't cross-examined him. That statement by Detective Gaither and or Detective Dennis, Your Honor, to me, just cripples. It tells the jury the police know something that I have no idea where they get their information from. It's their belief. There's not a scintilla of information in this 868 terabyte of discovery or the trial yet where anybody except the police theory has said that Jeffery Williams asked anyone to commit a crime. That is all from the mouth of the prosecutors and the detectives over objection. So I don't want this to be included. And then you have a murder. That's a murder. It's not, go and steal that bicycle from the child and then we'll get him a new bicycle. This is the ultimate. So Mr. Copeland is saying, I heard it from another person. The state, I'm going to another argument. The state then says, well, we need that as the foundation for why did Mr. Copeland go to Mr. Kendrick. So to me, to explain conduct, to me, the fact that Mr. Copeland went to Mr. Kendrick to explain Mr. Copeland's conduct, why is Mr. Copeland's conduct matter? It's Jeffery Williams' character that through totally hearsay statement. Mr. Copeland never says, I confronted Jeffrey and he admitted it in this interview. There are other areas, by the way, that you're not privy to potentially that are on recording where this comes up again, but that's more direct. Right here, this should be excluded to me. And I don't know why it explains conduct where Mr. Kendrick said that's not true. What conduct are we explaining? So I believe effect on the listener is just a way that this prosecution is trying to give you some choice words to have you rule with them. But I would object to for all those reasons. And 403. The bottom line is, I'm not saying it's admissible, but I'm saying it's totally the state's theory of the case, and under 403, that should not come in through detectives telling a witness that is a lie. He paid you to commit crime. He gave you money. I mean, to me, I don't know how that should come in on this recording.
May I just address that?
Okay, Mr. Steele, you done?
Yes.
Okay, all right. Okay, go ahead. Ms.
You're right. Remember, the reason why we're here at the recording to be played again, and I should have started here, is this is all impeachment by contradiction. Again, in court, Mr. Copeland has said, everything I said there was a lie. So one, we're contradicting his in-court testimony by even being able to play the interview. So let's start with the foundation as to why we're even playing the video.
I don't think he said, remember we looked for that? Everything I said was a lie.
Well, he said that I made it all up. But I recall, I think I asked him on one of my questions, I believe to him, is why would you lie to the police? Why would you lie to the police? If you're trying to get out of jail, why would you lie? I think that I had a line of questioning that said that. But again, in court, he has said, I made everything in my interview up. I just said whatever it is that they wanted to hear so I can get out of jail. So now the jury gets to see his prior statement to see if they can determine that he just make this all up. Because again, in court, he's trying to say everything I said before, I made it all up. I made it all up so that I can get out of jail. I told the police anything I wanted to tell them so that I can get out of jail. Again, this interview is in direct contradiction to what his in-court testimony is. So the premise of why this interview comes in starts there. This is impeachment by contradiction. Once we get past the impeachment by contradiction level, then we talk about the contents inside of the interview. And again, this contradicts everything that Mr. Copeland is saying, which is the police only wanted Thug. The police only wanted to force me to say something. No, they're trying to get information out of him. And when he's talking about the money here, I want to be very clear. He's not talking about Mr. Williams paying him to do a crime. They're just asking him, has Mr. Williams ever given you money, period? And he's saying, no, the only amount of money he's ever given me is $1,000. He's given me $50,000 to flash in the club, but for me to keep has only been $1,000. So this conversation about money is not about whether or not Mr. Williams has paid him to do a crime. It's about whether or not Mr. Williams has ever given him money. And he's saying, no, that.
And what's the relevance of it?
What's the relevance of the money portion?
Yeah, I mean, if it's not being given for illicit purposes, what's the whole purpose of it?
Again, to show the relationship between him and Mr. Williams, that the state's theory is when he's talking about Mr. Williams in this interview, we believe that he was being truthful in this interview. And if he had a great relationship with Mr. Williams, there'd be no reason for him to lie on him. That is what we are trying to show. So the fact that he's talking about the amount of money that Mr. Williams gave him, the fact that he used to travel with him, again, he's showing that he had a relationship with Mr. Williams such that here, there would be no reason for him to lie about his involvement in the murder of Donovan Thomas Jr. So that is relevant to show their relationship between one another.
Hey, I'm just asking, are you trying to point out the fact that if the relationship was so good, why do you give his money back? Or is that what you're trying to impeach him on, or what?
So we're impeaching him first and foremost on his in-court statement versus the interview. So we're saying everything he's saying in court is a complete contradiction to what happened during the interview in 2015. So that's layer one. Layer two is during this portion, 'cause I want to keep this portion in context. He begins this portion talking about the fact that Thug wanted to have him killed because he's talking to police after the murder of Donovan Thomas. And so what the investigators are establishing is that one, him and Mr. Williams had a relationship, a good relationship. As a result of him talking to police, that relationship is no longer good anymore. He believes, one, that Mr. Williams wants to harm him because he's talking to police, and two, Mr. Williams is not even having the same relationship with him anymore because he's talking to police about the murder and everything that had happened between January and June. So again, it's showing the relevance of why this relationship is changing, given the fact that he's talking to police after the murder of Donovan Thomas.
Okay. All right.
When you're ready, Judge, can I add one more layer, please?
Oh, go ahead, Mr. Harvey.
Thank you. I understand the arguments that have been made. We also made the other day the argument that this particular statement has been made after the witness had a motive to falsify. Therefore, under Tomei and the relevant authorities, it's not admissible as a prior inconsistent statement.
I don't think they're using it for an inconsistent. They're saying it's impeachment by contradiction.
I understand that. So,
All right, so
the
different than
okay, the only basis then is impeachment by contradiction. So if that is the precise reason, then I have a question as to whether or not that is admissible as substantive evidence or admissible for impeachment only. So that as far as I'm concerned, once again, if it is admissible as impeachment only, then I am entitled, and everybody here is entitled, to a 105 instruction under 801 E1E. So that's I think it's being admitted for impeachment only. It is not substantive evidence, and therefore I'm entitled to a instruction under that code section.
okay. All right. Thank you, Mr. Harvey. Ms. Hilton.
We have a 2004 case, but we'll find a more recent one. It comes in that substantive evidence. In the case that we have is Robinson v. State, 278 Georgia 31.
Let me look at Robinson.
Your Honor, we're gonna look up a different case. I think the Robinson case was prior to consistent statements, but give me 1 second.
State, did you find something else that the court's found some more recent based on all that?
Your Honor, what we have, and I'm reading from Carlson's, the 8th edition, what we have so far is just that federal jurisprudence identifies it.
What page on Carlson are you in?
Page 350, page 350.
Page 350.
While impeachment by contradiction is not expressly mentioned in the federal rules of evidence, the concept existed as common law and has been inferred from the rules pertaining to relevance and Rule 607. So we do believe that when you impeach by contradiction, that does come in as substantive evidence.
That's a pretty thin read.
Well, Rozier, Rozier versus the state from our Court of Appeals decided in August of 2022, 365 Georgia Appeals 178 seems to indicate that that a witness testifies. In this case, an eyewitness testified at trial was available for cross-examination. It comes in as substantive evidence as well. So, but we can take up all that stuff. I will have to give instructions on that later as well. So, Mr. Harvey, I'm not going to give a 105 instruction at this time.
And
Over your objection, sir. I'll give you a continuing objection.
a continuing objection,
Yes, sir.
please, Judge. And I note that Rozier is a prior inconsistent statement case again. So I don't think we have established that.
But I've also taken a look at Chaparro as well, and Chaparro does indicate that as Ms. Hilton has indicated.
All right, so
But like I said, we'll take up that issue. I may have to, depending upon what happens, Taylor or otherwise, figure out what that applies to.
well,
Okay, all right. Anything else, sir?
no, sir.
Okay, all right. Okay, in considering the parties' request to admit or to keep out page 62, line 23 to page 70, line 16 or thereabouts, the defense contends that, and this is a compilation of Mr. Steele and Mr. Shart's objections, primarily Mr. Steele, on behalf of all defendants, that they wanted to omit it because it's It inserts personal opinion, it violates the confrontation right, it's speculative, it's hearsay. And in applying a 24-4-403 prejudice, they claim it's more prejudicial than probative. The state counters to saying it's relevant for several reasons. And they start off with concern about speaking to the police, that is Mr. Copeland, that Mr. Williams wants to harm Mr. Copeland. And what he does after that being the effect on listener as he approaches Mr. Kendrick or Yak Gotti about this conversation with Valerie. And then it gets into Mr. Williams, giving him the witness, Mr. Copeland cash, and that he is in Mr. Williams' songs. The state is of the opinion that this is impeachment by contradiction. It shows the relationship of Mr. Copeland and Mr. Williams and the investigation thereof, and refutes that this, what was done in this particular case. The court is of the opinion that it does fall in the category of impeachment by contradiction, and in applying a 403 analysis under 24-4-403, the court is of the opinion that it is more probative than prejudicial. So I'll allow it to be played, and I'll give the defendants, Mr. Steele, a continuing objection as to that respect. Okay? All right. How about we take 5 minutes, take a comfort break? We can come back, okay?
Thank you.
All right. We're in recess. Okay, let's go ahead and continue with, where we are. Okay, I think the next, period of redaction is ten 1842 to 10/19/12. And apparently that is line, or I should say page 61, line 6 to page 61, line 24.
We're past that part.
So,
We're on,
Well, okay, I just want to make sure you've agreed to it, because I have it on Mr. Shart's chart that he sent me.
so just to make sense of the chart, Your Honor, on the left, where it says page number on the left,
Yes,
that's
sir.
the state's proposed redactions.
Yes, sir.
Where it says max page number, that's mine.
Okay.
And so I just tried to keep them in order. However, the last one, which I don't think we're done discussing yet,
Which is the last one you're talking about?
where I said page 61 to 77. Mine was broader than the state's individualized ones. So we've already passed the next three for the state, but we're still waiting through 61 to 77 on my end. Does that make sense?
Yeah, sort of. Okay.
Okay.
All right. Okay.
I'll
So
take sort of.
so do you have any disagreement with the state's redactions from 10/18/42 to 10/19/12, 10/19/42 to excuse me,
no, that's
to
it.
10/19/50, and then 10/25/23.
No, I'm in agreement with all of those, and actually that last one,
10/25/23.
right, takes us to where we left off, where there's a brief mention by or commentary by the detective that suggests that Shannon is Jeffrey's shooter. And so the state, that's the 10/25/23, which the state is taking out. Now, now, in my opinion, we have to wade through the time period after that until we get to page 77.
So the next portion, Your Honor, that I'm not sure if it's in contention, but it would be page 70, line 21 through page 72, line 4, which is about 10/25/27 to 10/26/13.
Right, and that is just to get everyone on the same page, because I have the transcript for the defense. That is there's more commentary in there from the detectives stating their opinion that Mr. Copeland has in fact committed crimes on behalf of Jeffrey. And they're saying, why would he put you in these songs if you haven't committed crimes for him? So I'm going to leave that to Mr. Steele. Okay, so Mr. Steele, Mr. Steele in the defense, for the reasons stated before by Mr. Steele, objects to that portion.
And I can just play it, Your Honor.
And that is the 10/25/27 to 10/26/13. Is that what you're saying?
Yes, Your Honor.
Okay, all right. Okay. I'll hear. Do I need to hear it?
Yes, sir.
Okay.
Here, I'm just gonna keep playing from where we stopped, and it'll pick up that portion.
Wait, this. He made these songs when Nut got killed. It don't matter. What I'm saying is, this story, you wouldn't believe me if I said, I probably told you this already. But before Thug was just saying things. We wasn't hanging with Thug, I know, you know what I mean? So this nigga said, he said, yeah, no one. I promise you this, why though? Let's put it this way. This Thug, y'all you said no. And I said, well, why would he say, if I got a problem, so we can pull up the pop at that night? Yeah. And he doing it. I mean, ask him, how he put my name in these songs? He wasn't bad about it.
You want to know what it sounds like, Kendall? It sounds like that you expanded.
So we stopped it at 10:26:17, but that is, we played a little more because this portion will actually redact after this, but the period between 10:25:26 and 10:26:13, he's talking about the fact that some of these songs were made prior to Nut being killed, and the fact that they weren't hanging with Mr. Williams prior to him being famous. And so they're talking about just when their relationship began, Your Honor. I think it's going to be relevant for the jury. And the portion that they're talking about with the detective, she's clarifying what she had already asked him. She said, I asked you, have you ever committed for a crime for Thug? You said no. And I said, well, why would he say, if I got a problem, little Rudy will pull up and pop at your noggin? And then Mr. Copeland responds, he keep doing it. I don't even ask, but like, why the hell this nigga put me in his songs? And so, again, that's Mr. Copeland. It's Mr. Copeland saying he doesn't know why Mr. Williams puts him in the songs.
Has he given testimony about that already on direct?
Not specifically, because again, once he said everything he said in here, he made it all up. We, based on the case, I have not gone line by line because he's basically said at this point, everything he said, he's making it up.
So what's your theory of admissibility in terms of these, this particular line of inquiry from line 70, from 10:25:27 to 10:26:13?
Here again, it again goes to the relationship of Mr. Williams and Mr. Copeland prior to this incident occurring. He's telling the detectives about when they met, when these songs occurred. So again, I think that's just relevant to talk about their history of how when they first met. Is why I believe it's relevant, and again, it's in contradiction to what he's saying, what he said in court, which is that he made all of this stuff up in all of these interviews.
Mr. Charter, Mr. Steele?
Your Honor, Mr. Copeland testified that he has a relationship with Mr. Williams. The jury can determine what type of relationship, if any, that was. There have been social media postings. There have been pictures together. Mr. Copeland testified already that he met Mr. Williams after Mr. Williams was already an accomplished, well-known musical artist. This adds nothing, but if the state wants to put in a consistent statement, I don't know how it's admissible, that they met, that one line that they met after, that Mr. Copeland met Mr. Williams after he was an accomplished artist. I don't oppose that. What I do oppose is the detective's statements again, and the fact that this is getting to, if you didn't commit a crime for Mr. Williams, why would Mr. Williams put you into a song? It's impossible for Mr. Copeland to pontificate why Mr. Williams does anything in a song without a foundation saying, I discussed that with Mr. Williams, which is not his response. And that's the part I'm objecting to, because it's, again, the detectives giving their theory that you do commit crimes for Mr. Williams, otherwise you would not be in a song. And Mr. Copeland denied that. And then they followed it up with the, well, then why would he put you in a song, which clearly Mr. Copeland could not get in the intent of Mr. Williams. Those are my issues. Also, the state keeps saying that Mr. Copeland gave this blanket assertion, I lied. And I know I heard what you said today, and I know you looked at, that's not what he said. What he said was, I probably said all of these things you're asking, but I said them because I wanted to remove, basically, this is my impression, the target from me onto someone else. That's how I'm not saying that's a direct quote, but that's how I understood what he testified to in your court. So those are my reasons. And under 403, I don't know why the detective's words get to be displayed to the jury on, oh, well, you had to have committed crime for Mr. Williams. That's Mr. Williams' character under 408, and it's also a 403 analysis again, I'd ask. Well, excuse me. From those detectives. And confrontation.
Can you all play it again for me, please? That 10:25:27 to 10:26:13 or thereabouts, please.
He made these songs when they got killed. It don't matter. What I'm saying is, this story, you wouldn't believe me if I said, I probably told you this already. But before Thug was just saying things. I was not saying he was Thug. I know. You know what I mean? So this nigga said, he said, yeah, no one. I promise you this. Why though? Let's put it with this Thug. Y'all in it. I hope you said no. And I said, well, why would he say if I got a problem, Lil Woody will pull up and pop it at night? Yeah, and he keep doing it. I even asked like, why they doesn't he put my name in these songs? He wasn't bad about it.
You want to know what it sounds like now, though?
Your Honor, we can take it out.
Okay. All right, that will be omitted. That being 1025, 27 to 1026, 13. Okay.
The next portion is 1026-14 to 1026-24, which is
Oh.
page 72, 5 and 13, and we don't have any objections.
All right, gentlemen and lady, any further objections? The state says they're gonna omit that, so.
That next one, no, Your Honor, that we agree. And next one after that, I believe would be page 73, line 22.
Well, before that, I don't know if this is objecting to page 72, line 14 through page 73, line 21.
I'm not.
Okay.
Anyone else?
I think we're all in agreement until we reach page 73, line 22.
Yeah, and so the state does not object to page 73, line 22, I think through page 76, line 12.
Have through 78, line 4, but let me just see.
Oh,
Yeah.
okay, yeah. I'm sorry. Really, I have up until page 78, line 16.
78, line 16.
I think the whole. So the whole line.
Yes, that's good.
It's.
Everybody, you're good with that?
It's more talk about the wing bus.
Yes, all of this section, and it really starts from page 73, line 22.
Through 78, line 14, or line 16?
Yeah, let me just go.
Okay.
Yes, through line 78, page 78, line 16.
Okay. What's the next area that you'd like to discuss?
So the next area that I believe is on Mr. Shar's chart is page 89, line 3 through 6.
3 through 25.
Okay, well, we did have objection to 3 through 6. Now there's another portion we would need to look at there. Yes, Your Honor. So on page 89, 3 through 25.
Page 83, you mean? Is it 83?
Page 89. Sorry, I thought we were page 89.
Is it 89 or 83?
Mr. Shaw, I have 89. I'm looking at Mr. Shaw for confirmation.
Okay.
89, 3, I think it's 89, 3 to 93.
Oh,
I
well
think.
then we have some it expanded. First I thought it was just 3 through 24.
Yeah, I'm trying to, it's tough because he keeps going, kind of shifts topics. Yeah.
So is it page 89, lines 3 through 25?
Um,
That was the original group, so we don't object to that 89, 3 through 24, but you added stuff.
24, I should say.
so, and we appreciate the state agreeing to page 89. On 90, the difficulty with this, Your Honor, and this is going to be a call that you have to make. Mr. Copeland, when he's telling some of these stories, he begins with, this is what they said, and there's not a clear delineation from when he is speaking on what other people said to where he's speaking out of some sort of personal knowledge to where he's speculating. 90, on page 90, I'd ask Your Honor to take a look at that. He continues to, this begins on page 89 where it says, I'll tell you, they come in too because they saying Birdman wanted to sign Bloody J. So it begins with,
That's line 3.
yes,
on page
so
89.
so it begins with they saying. At some point, he's talking about, continues to talk about business relationships of who he calls Thug and Birdman. And then he's asked about gang membership and rankings of different individuals in the gang, including Shannon, Mr. Kendrick, and Jeffrey. So
Where is that particular?
on page 90, as you go
Okay.
further down, and I am expanding it, so I will apologize to
Okay,
Ms.
so-
Hilton. But
Before we go further, is the state in concurrence that you're that line at page 89, lines 3 through 24 should be omitted?
Yes. we don't-
Okay, all right, so unless somebody has an objection to the contrary, anyone? Okay, let's start on page 90 then. And you can further your argument. So which lines or which pages, starting at page 90, are you saying that should be excluded?
well, 1 to 3 seems to be a continuation of the redacted conversation. But then after that, they talk about gang membership. They say, what's Thug's ranking? But Thug ain't blood. They say he won't answer the phone for him.
And
See,
that starts around line 11.
11.
Okay,
And so it's they say, so that's, seems to be based on hearsay. And then they ask about what rank he's claiming, and he says, SHIT, last I heard, like, cause Shannon's supposed to be G-Shine, and Yak's supposed to be some other blood set, some bounty. I listened, I heard bounty type SHIT. I don't know, is Copeland's response. So it seems to me that this gang information on page 90 is a combination of what he's heard and speculation, and then he kind of ends it with, I don't know. So I don't think it would be appropriate to play such flimsy evidence with a source that's cannot be determined for the jury.
I think it's probably best in this section, because I don't think the transcript gives the context of what the section
Okay,
is.
all right, let me hear it, please. And what part of the transcript, this
I'm
reports the
gonna-
record, is it?
Yes, Sharon, we're gonna start page 90, line 1, and it'll be approximately around 10:38:20.
And Ms. Hilton, I'm just going to make a suggestion that you continue it on to page 92, because the conversation continues on beyond page 90.
Okay.
Thank you.
So you're gonna play it from 10:38:20 to approximately 1 minute.
10:40:36.
Okay. Okay, whenever you're ready.
It's gonna start a little bit earlier, Your Honor, at 10:38:16.
Man, Jay, because they supposed to be telling other people about Thug, being gay. That's what this was about. They were not that cool because Thug said they didn't talk about it. You get it? But see, these artists, you know what I'm saying? Like, it's like now, new artists, new. So Thug had Birdman, like, you know what I'm saying, this neck. You know what I'm saying? That's why. And then they got to it. What's Thug at Frankie? They saying Thug ain't blood. They say going out the phone for him. See, he's just saying he a blood. Then he went on the phone for folks. Yeah, top dudes. Yeah. What ranking is he claiming? Or claiming to be? Last time I heard, like, Shannon's supposed to be G-Shine, and Yak's supposed to be some other blood system, some firearm type shit. I don't know. You said bounty? Yeah, I ain't sure what yet. So probably some shit. And they been arguing about everybody being this shit, and they're like, yeah, about 6 months Rolex and whatever, however you said. Yeah. And like, ain't nobody getting that. So what is, once again, what rank did you hear, or what rank is Thug claiming to be? The last time I heard he was sustained, it was like, he was over all the people there. What is the name of the sustained? I don't know how they, like, they got different stuff for different blood cancers. Okay, he's supposed to be slurred, SMM, whatever. Yeah. So what's the stain for that game? Because I know, they got, you're not listening to them, they got different stains. I don't know how much stain he got. They don't be like 5 animals. Don't say shit like that. Mm-hmm. They come out M shit, so I don't know what they mean. So M something. Yeah, M5, Something like that. I don't know what it means. So there was T who was M5 until the desk box there shit had got convicted or what happened. Now when he got locked up, they said he for testify. So they took his name. Yeah, and they made him do it. So he gets signed or it's hit a YSL or whatever. How you gonna put it?
So
We stopped at 10:39.
All right, state, got a lot of references to third parties. What's your basis? Are you still want to try and argue that it should come in?
Yes,
Okay.
Your Honor, again, first level and by contradiction. He said that everything, he made it all up. So I start there. Then secondly, when he's talking about who is a part of what set or what gang, Mr. Copeland hangs around or is around all of these people all the time. That's
But we don't know who. I mean, it's they.
right, but I think that is just the way in which he speaks. I mean, he's around Mr. Kendrick. We've seen pictures of him with Mr. Kendrick. He's around Mr. Williams. We've seen pictures of him around them. So he has an understanding of what they call themselves or what they identify as. And so he is telling them that is what they say. They claim that they are this. They claim that they are this, but this is not a third party telling him these things. He is friends, or at least at this time or prior to this, friends with each and every last one of these individuals, from Mr. Stillwell, Mr. Kendrick, and Mr. Williams. So he is telling the officers what he understands them to claim. And so we don't believe that they is a third party telling him something aware of. We believe that he has knowledge, personal knowledge himself, being that he hangs around or that he is with these individuals, as evidenced by the pictures that we've already introduced into evidence showing his relationship with all of these individuals.
All right, is that it? Okay. Mr. Sharp or Mr. Steele?
Well, it's completely unclear what they refers to, who they refers to. The state is making their own determination that favors their theory of admissibility, but that doesn't shine through in the transcript or in the recording. What does seem clear from the recording is Mr. Copeland is getting information from somewhere else, and he also really doesn't know what he's talking about, or at least he claims to not know what he's talking about. He says whatever it is, I don't know about that. So he's just in. We all know people like this that say a lot, and then at the end of that long statement about everything say, but I really don't know that to be a fact, or I don't really know about that. And it just seems to me that if he doesn't know about what he's talking about, and we also don't know where he got his information from, that is not something that should pass 401 and 403 balancing tests, and not something that should be exposed to the jury.
I do want to point the court to one specific line, which I think is actually the crux of this. On page 91, lines 5 through 8. What Mr. Copeland says, and I think that puts the other portions before it in context, he says, and they were in there arguing about everybody being dipshit. And they was like, Thug saying everybody sex, money, murder, Rolex, and whatever, however you say it. So one, that portion, Thug saying everybody sex, money, murder, Rolex, and whatever, however you say it, would be a statement against a party opponent. Prior to that, I think what Mr. Copeland is saying is that they were claiming these other sets. G-Shine, Yak was supposed to be some other set, but whenever they're arguing, Thug said all of them. Everybody sex, money, murder, Rolex, or whatever, however you say it. So that portion is statement against a party opponent. The portions before that is him trying to say all these people are claiming these other blood sets, and then he in turn, Mr. Williams in turn says everybody's sex, money, murder, or whatever you may call it,
Well,
or
again,
however you say it, excuse me.
again, we run into the same problem in that line that Ms. Hilton just read. And they was in there arguing about everybody being, it says dipshit. I'm pretty sure that it's not dipshit that he said. And they was like Thug saying everybody sex, money, murder. So again, we don't know who they is. We don't know about what they were arguing everyone being. And then he says, and they was like Thug saying everybody. So the they is in apparently telling the unknown they is now telling Copeland what Thug supposedly said. So it's still hearsay. It's an unknown declarant. And that doesn't, and even if Your Honor were to accept the state's argument on this one particular set of lines, that still doesn't address the source of knowledge for my client's gang membership, according to Kenneth Copeland, and Mr. Kendrick's gang membership, according to Kenneth Copeland, which right after he gives this information says, you know what, I don't know about it. So it's just a lot there, and I don't believe that this is the type of evidence that is of the quality that should reach the jury.
All right, in considering transcript 1038:20 to 1040:36 or thereabouts, the defense claims that they don't know what they, I should say, refers to, and he's getting, him being Mr. Copeland, his info from somewhere else, and the unknown they is giving Mr. Copeland information. The state says this is impeachment by contradiction. They is a reference to what the witness, Mr. Copeland, knows, and that's just the way he talks. And this refers to his personal knowledge. The court is of the opinion I have to take a look at the most plain reading of the transcript and listening to the audio, and I'm inclined to agree with the defendants that we don't know who they is, and for that reason, I'm gonna exclude that particular part of the that to be played. 1038:20 to 1040:36.
And thank you, Ron, but can I go to a specific portion? And I understand the court's ruling. On page 91, line 20 through 22, which is a small portion of that section, Your Honor. When the detective asks Mr. Copeland, okay, he's supposed to be slime, SMM, whatever, he says, yes, yeah. That particular line, we believe, is based on personal knowledge. So we understand the court's ruling as to everything above and everything after, but we would ask for those two lines, because that's not a they, that is, they ask him a question, okay, he's supposed to be slime, SMM, whatever, his response is, yeah.
All right, Mr. Shart or Mr. Steele? The state is asking for, I'm going to exclude the previous portion, but the state is asking for me to include around line 20 of page 91, where Detective 1 is speaking. Okay, he's supposed to be slime, comma, SMM, phonetically, whatever. And then that's line 21. And then line 22 is Kenneth Copeland, yeah.
we agree with all our other objections to playing statements notwithstanding.
Yeah, and they're still on a fundamental
Yeah,
basis. You've objected to that already, so.
That's fine, Your Honor.
All right, Mr. Steele, anything further, sir?
No, sir.
Okay, all right. I will allow the state to play the line 20 through 22 over the basic objection. The defense doesn't believe that it's proper for the state to be playing this to begin with. And I've given them a continuing objection in that respect. All right. Hold on one sec, sir. Okay, so where are we now?
I have 112:24 to 114:25.
Said 112. Oh, I see it. Okay, 112:24 to is that page 112, sir?
Yes,
Okay, hold on.
page 112, line 24 to 114, line 25.
And Your Honor, the state has no objection, but I do believe the lines may start at page 112, line 21 through page 114, line 25.
So it's, you think it begins at page 121?
No, 112, but just.
Page
line-
one, hold on, 112.
but just line 21.
I agree with that.
112, line 21.
Yeah, it's like after a period, but it starts like I got out of jail.
I got you. Okay, all right. Through where?
114, line 25.
All right. Any further objection or discussion in regards to those pages 112, line 21 through 114, line 25? All right, hearing none, those are excluded. Okay,
And that redaction covers the state's next redaction, proposed redaction, which we would agree to, and it was covered in that last one.
yes.
So
we
I
would.
think the next is page 122, line 19, 124, line 10.
I have it started slightly differently, but you don't object to it. We have page 122, starting at line 20, and then going into 124, line 10.
And that's fine. I picked a smaller part of a larger story, and we can take out the entire story.
So that, it'll start where?
It'll start, we have this page 122, line 20 through 124, line 10.
All right, any further discussion in respect to the page 122, line 20 through page 124, line 10? All right,
And you're on, the time is 11:02:31 through 11:04:01.
11:02 what?
31
Uh-huh,
through 11:04:01.
okay. All right, that'll be excluded.
And you're on, for the previous portion that we just discussed, the page 112, I'll give the court the time as well.
Go ahead.
That's 10:55:49 through 10:57:18.
All right, thank you. Okay.
The next section, Your Honor, is defense has page 129. I believe the portion is page 129, line 18 through 25, and then goes into page 130, line 1 through 20.
Okay.
No, page 129. And we don't,
You agree that should be taken out?
yes.
Now, there's, and I'm in complete agreement. After that, after 130, line 20, there's a discussion that the detective has about, this is just context, Your Honor, it's the shooting of Mr. Bennett's mother's house. And then the detective talks about a gun that Quamarvious Zachary had been locked up with, matches the ballistics coming back to the shooting of Mr. Bennett, who we've called Lucci before, his mother's house. Now, speaking for myself, I don't have a problem with that discussion on the assumption that the state, what I think is inappropriate is if this discussion enters evidence and the state is not going to produce any witnesses that make the ballistic match between a gun and the shooting at Mr. Bennett's mother's house.
We do intend to introduce ballistic evidence showing that that gun matched the ballistics from the second shooting match the gun that was found on Quamarvious Zachary. It may. So for context, Your Honor, on January 20th, Mr. Bennett's mother's home was shot up twice on January 22nd, 2015 and January 26th, 2015. The shell casings from the January 26th, 2015 shooting matched a gun recovered from Quamarvious Zachary in May of 2015. The state does intend to introduce evidence that the gun found on Mr. Zachary matched the shell casings from that incident. From January 26th.
Our stance is until that link is made through evidence that this part of the statement should be redacted.
I would concur. I would concur until that evidence is actually put forth in your case in chief. I'd exclude it at this point.
Your Honor, I believe, and I just need to double check, and if you give me a moment, I thought Detective Dennis talked about it during his presentation during his testimony, but I need to confirm. I think he talked about it. Now, whether or not did you introduce? Did I introduce the shell casings? No, but I believe that there is evidence of it, given that the testimony of a single witness is enough to establish a fact, that the evidence is before the jury. I will confirm and make sure that Detective Dennis did testify to it, but I believe he did. But I would just need a moment to go through or ask Ms. Weaver for assistance to determine if that evidence came out with Detective Dennis or Detective Gaither.
But was ballistics ever entered through Detective Dennis in regards to this, or are you going to enter it later through another witness?
Ballistics was not entered, only the testimony, but the testimony at this time is enough to establish a fact. But no, the ballistics are not in.
And to be clear, my strong recollection is all this overview testimony by Investigator Dennis about other alleged acts, that was all made over defense's objection. He wasn't.
Yeah, I think you still need to lay some foundation on that state. I mean, I do, in terms of the ballistics, is testifying about that. If it,
I understand the course, the state, I understand the court's position, the state's brief argument, even if it came in over objection, that testimony is still before the jury. That testimony is still evidence, but I do
yeah,
understand
but
the court's.
the defense has made another objection, and the court is of the agreement that it's still foundation. You still would, you still need to lay some more foundation in regards to the ballistics for that to be then testified to. I understand what you're saying. You're saying, okay, we can testify about this because of the fact that Dennis may have already testified about the ballistics, but there's nothing underpinning that yet. So.
Thank you, Your Honor. And we just want to confirm that the portion that we will keep out is the portion specifically talking about the fact that the ballistics came back. So that would be
For now, I mean.
page
yes.
131, line 21 through 24.
Page what, 131?
I mean, no, page 130, line 21 through 24.
So there's also 131. 5 through 15. Oh, I'm sorry, 131, 5 through 25, pretty much.
I'm sorry, Mr. Sharp,
131, 5 to 25. They keep making reference to the ballistic match.
Okay, yes, that's fine. So from page 130, 21 through page 131, line 25.
Right.
All right. Folks, you want to stop here, given the fact it's right at lunch, and ignore the bell. That's of no consequence. Do you want to stop now, and then we can pick up at 1 o'clock?
Yes, sir.
Okay. All right. Where are we going to pick up at 1 o'clock?
Your Honor, we should be picking up at the fence, page 140,
Correct.
which will be line 11, I think through page 143, line 16.
143 what? I'm sorry.
Page 140, line 11 through page 143, line 16.
Okay. All right. Also, for purposes of our continued discussion after we exhaust this from Mr. Sharp, I am now in possession of Mr. Adams' proposed redactions that pick up from there. And I will include that email and its references to Ms. Weaver as the next court's exhibit in order. And we'll begin to exhaust that once we finish with Mr. Shart's. Okay?
Thank you, Your Honor.
I think I emailed that to you.
You did, sir. You did, sir. All right, okay, so we're in recess. We'll see everybody back at 1 o'clock, okay?
Thank you, Your Honor.
All right. Thank you. Okay, we're back on the record. Councils, thank you for your patience. I had to take up some business. It took a little bit longer than I expected. So I think we left off with page 140, line 11 to page 143, line 16.
Yes, Your Honor, and I just play that portion. And it should begin at approximately 11:16, 19 through 11. My numbers might be off. Hold on one second. 11, something's wrong.
I'm sorry, what part of the you're
Okay.
playing from?
It
I'm
should be
sorry.
11:16, 19 to 11:18, 17.
Are we? This is the page 140?
Yes, page 140, line 11 through page 143, line 16.
Oh, okay, all right.
When you shot at Taylor? Yeah. This one I didn't get a chance to get out the gun, that you ain't give me the gun back. You know?
And I'm gonna go back, Your Honor.
But the gun that I had shot at with, that was Shannon gun. When you shot at Taylor? Yeah. This one I didn't get a chance to get out the gun, that you ain't give me the gun back. You know? When the police came to the house, Shannon right there. You didn't come. Shannon right there. What was the gun? The gun right there. You know what I mean? The gun was right with it. The gun just like, I never took the gun over. I was so scared and I was just like, I'm just defending this. Right. So, where was the gun when the police got there? The gun was like, I had put it in the house. You know what I mean? So when I was asked what the gun was, I'm like, shit, I can give it to you. Like, give it to me. But Shannon went in there and got the gun and left with it. I mean, so that's why I was like, give me another thing. That's why,
What kind of gun was it?
huh?
What kind of gun was it?
A clock.
A Glock, what, 49?
It was on 40. About this long. And that's why you had when they got the magazine. The clip, yeah, the clip. So it was Shannon gun, but when the police asked for it, he didn't want to give it back. Right. I ain't gonna give it to him about the new kid. I was gonna give it back though, because I didn't want to go to jail for it. Right. So when Shannon went and got the gun, that's why I told her I wanted to tell, like, let me talk to you, when I talk to you, and you like, get you that gun. But when I tried to get the gun, Shane said he wouldn't give it to me, then he went on the show with Thor, he left. But that's not exactly what you said. You said that
Walk down the street.
K or D or somebody you wanted purchase gun for. No, you getting wrong. Okay, well, you saying it's not the Glock from the night of the shoot. Yeah, they shot at your girl morning. Yeah, right. Shannon left with the gun. Okay, well, this is the first you telling us about that. I'm just going. Nah, I told you. I just like somebody ain't got the gun. Right, you did. But Shannon who got the gun. He still got the gun though.
What do y'all use to get all these guns?
We're stopping at 11:18:20.
All right, Mr. Sharp, sir?
So a couple things that I object to with this. Obviously, it's character evidence about my client owning and possessing a gun based on my client's status as a convicted felon at that time. That would be an illegal act. We have not been given any 404B notice about this previously. So that's my first objection. It's not charged conduct either. And finally, a foundation hasn't been laid to play this portion of the tape. The state did not confront Mr. Copeland and say, in the interview on June 10th, 2015, did you tell Investigator Gaither that after being shot at that outside your house, Shannon, that was Shannon's gun, Shannon took the gun, Shannon wouldn't return the gun, etc. He's never been confronted with those prior statements, so I don't think the foundation's been laid for either.
As to Mr. Copeland.
Right. I don't think the foundation's been laid for either prior inconsistent statement or impeachment by contradiction.
Is there a requirement that the declarant be confronted as to that?
Yes.
In this particular circumstance?
I would, yes. That's definitely for prior inconsistent statement, but again, I don't know how a contradiction can be established without first getting the side of the story that you claim is being contradicted.
You hold on one second. All right, Mr. Shard, anything else, sir?
I know.
Okay, Mr. Steele? Anything, sir?
Just adopt the same, can't just play the recording.
Okay,
No foundation for it. Thank you.
all right. Anybody else? Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
Yeah.
All right. Misty Williams? Mr. Harvey? Okay, all right. Okay, State, why do you believe it should, I want to hear it, but why do you believe it's admissible?
Okay. So, Your Honor, first to address that the foundation has not been laid. Yes, the foundation has been laid about the gun. And any of his statements in these,
How has the foundation been laid?
because when he says, I don't remember anything that I told the police, coupled with everything that he is saying, he made it all up. That is the foundation to which we get to play his prior statement.
Does he have to be, confronted
No.
with it, as Mr. Short mentioned?
He does not. The moment that he says, I don't remember anything, we can confront him with all of his statements, especially when he says, I don't remember anything I told the police and everything I said to the police, I was just making it up. We don't have to confront him with every single line in his statement, and I'll find the specific case law that states that.
Yeah, do you have any case law which would indicate that this is one of the exceptions where he does not have to be confronted as to his statement?
Yes, we'll pull that. So while we're waiting for that specific case law,
All right.
further,
And what else?
when he says that the fact that Mr. Stillwell possessed a gun is not bad character in and of itself. So, Your Honor, I would like to direct you to 3 cases. The most recent is going to be Hill v. State, which is 2024, Georgia Lexus 140, which was decided on June 11, 2024. And specifically, that case talks about the fact that someone has a knife. Is not bad character, but they cite the Adams v. State case, which is the next case I want to provide to the court, which is Adams v. State 318, Georgia 105.
318 Georgia 105.
Yes, which is also a 2024 case.
All right.
And what it says is specifically that given that gun ownership and the custom of carrying a gun do not by themselves impute bad character. So solely for the fact that Mr. Copeland is saying that Shannon had the gun, that in and of itself is not bad character evidence. It would not impugn Mr. Stillwell's character. But even if the court thought it was an impugn on his character, Your Honor, this is intrinsic evidence in which would be admissible because this is inextricably intertwined with the evidence regarding the offenses in this case and is necessary to complete the story of this overall crime. If you can recall, Your Honor.
Did we have a hearing about this earlier?
It doesn't have to have a hearing. So intrinsic evidence does not have to have a hearing. And specifically, I'm citing from Johnson v. State, which is 312 Georgia 481.
Said 312 Georgia.
481.
Okay.
Evidence pertaining to the chain of events explaining the context, motive, and setup of the crime is properly admitted if it is linked in time and circumstances with the charged crime. So, Your Honor, here the charged crime is the murder of Donovan Thomas. As we've been discussing, after Mr. Thomas was murdered, there were a series of events that occurred. One is the shooting of Mr. Copeland with his child and his child's mother, which the court has heard testimony about. In his February 21st statement, Mr. Copeland talks about this gun, the gun that he used to shoot back at Tay, or shoot back at those who were shooting at him. And if you can recall that they kept asking in both the February 20th interview and the February 21st interview, where's the gun? Where's the gun? We need the gun. We need the gun. We need the gun. And what he's finally explaining in June is that the gun that they were asking for was Shannon's gun, and that Shannon had took it to Miami. That is why he could not give the gun back to the police. So
That's the same gun he said he was gonna go get, and he never did.
Yes, Your Honor.
They came and arrested him again.
Yes, Your Honor. And the reason why he could not give them the gun is because Shannon had took the gun with him to Miami. And now
I don't think that's accurate based on what was said. I think he said Shannon's in Miami. I don't think his gun was.
I believe he does say that Shannon.
He says in the transcript,
Yes.
I think, Mr. Sharp, I think that, let's see. Well, he says, remember, this is page 142. Mr. Copeland purported speaking. You know what I mean? So when Shannon went in there, he got the gun. That's why I told the detective, let me talk to you. When I talked to you, he was like, get you that gun. I remember I tried to get the gun. Shannon says he wasn't giving it to me. Then he went on the show with Thug. He left.
And if you go to page 143, Your Honor, he further says, and maybe I made the inference, Shannon left with the gun on page 143, line 7.
Yeah, Shannon left with the gun. That's
So
okay.
I just deducted by inference that Shannon left with the gun when he went on the tour with Thug, Your Honor.
Okay.
So, Your Honor, we believe that it comes in, one, it's intrinsic evidence. Two, it's not bad character in and of itself, the fact that he possessed the gun in this case, and also citing Williams v. State, 302 Georgia 474. And I'm just going to read this last line. Intrinsic evidence remains admissible even if it incidentally places the defendant's character at issue. Again, we don't think that Mr. Stillwell's character is at issue, but if the court thought it was, that the fact that it's intrinsic to Mr. Copeland now further explaining why he was unable to turn that gun in, it would not be an issue if it incidentally places Mr. Stillwell's character at issue, but we don't believe that this is character evidence at all, given that solely the fact that he possessed the gun in and of itself is not bad character. And Your Honor, regarding the assertion about whether or not we have to confront Mr. Copeland line by line, I'll cite the court Bridgewater v. State, 309 Georgia 882 at 887, which is a 2020 case.
You said 309 Georgia 882 at what?
At 887. Oh,
All right.
and again, Bridgewater specifically addresses prior inconsistent statements. However, we believe the principle remains the same for impeachment by contradiction, and that we do not have to go line by line once Mr. Copeland has denied, remember anything he said in his prior statements, and has said that everything he said, he made it all up, or he made it up, that we do not have to go line by line to impeach him with every single line in his prior statement.
All right. Okay. Mr. Shaw, you rose. Anything else, sir?
Yes, sir. My colleagues are looking at the Bridgewater case, but regarding whether this is character evidence or bad character evidence, to my understanding, the cases that are cited by the state are a little bit different than the facts here. And simply because, yes, I understand it is, according to the Supreme Court of the United States and according to the Second Amendment, it's pretty much everyone's right, citizen of the United States, to have possession of a handgun subject to certain restrictions. However, Mr. Stillwell, it can be distinguished, his situation can be distinguished from the individuals in those cases that the state cites. And that's because Mr. Stillwell is a convicted felon, meaning his possession of a gun would per se be a crime. And the jurors, as the state has made it clear by admitting probably 4 prior convictions of Mr. Stillwell, they've made it clear to the jury that Mr. Stillwell would have been committing a crime if he was in possession of a firearm at that time. So that's the difference. It is bad character evidence. All of this is subject to 403 balancing. And I'm not sure what probative value. Again, we're way, the state is labeling this is intrinsic. We have a murder case from January 2015. Then we have a unrelated shooting case upon Kenneth Copeland at his house, which happens approximately a month and a month and some days later, the state, I understand their theory, but there's really been no hard evidence that shows that these two events are at all linked. So now we're getting into the weeds of what happened to a gun in an unrelated shooting that happened around the same time, where the target was Kenneth Copeland, and what happened to the gun that he used to shoot back at the people that were shooting at him. We're way off in left field at this point. These are collateral matters, and the ownership of the gun that Kenneth Copeland was shooting on that day when people were shooting out of a car at him is of very limited probative value as to who killed Donovan Thomas on January 10th, 2015. And I think we need to keep that in sight and what we're actually trying to prove and what this case is about. The February 20th shooting that this gun was used in is not charged conduct in this case. And now we're getting into the weeds about whether this was potentially my client's gun that was used. And again, there's prejudicial harm towards my client that comes along with that information being given to the jury.
All right, sir. Mr. Steele, go right ahead, sir.
Your Honor, I think that the state's reliance on Bridgewater, BRIDGWEATER versus State 309 Georgia, 822, it's in Division 2. 2020 case is off the legal mark. This case in the fourth paragraph, our highest court specifically wrote, Bridgewater further challenges Davis's out-of-court statements to Thornton as recounted by Thornton, arguing that the state failed to ask Davis any specific questions about those alleged statements and did not identify the substance of those statements. As a result, Bridgewater argues Davis was never, and this is from the statute, which is 24-6613, afforded an opportunity to explain or deny prior inconsistent statement to Thornton, and the defense was unable to interrogate Davis about them. We disagree, and here it is, Your Honor. On direct examination, Davis expressly denied knowing Thornton and denied ever speaking to him. Although Davis appeared to contradict himself by saying that Rashawn, which is RASHAWN, gave him a ride to Short's mother's house, the prosecution later asked whether Davis recalled any conversation with Rashawn Thornton at all, and Davis replied no. And this is what the holding is. Davis's unambiguous denial that he had ever spoken with Thornton, as well as his assertion that he did not recall ever speaking with him, obviated the need for the prosecutor to ask Davis about specific statements made to Thornton and to provide specific foundation for the state to present extrinsic evidence of such statements. And Your Honor, here, what we have is Mr. Copeland never said, I denied speaking with the authorities, or I deny ever discussing Mr. Williams et al. With the authorities. He is saying actually the opposite. I probably did say all that. Let me explain to you why. So the state's reliance on Bridgewater respectfully is not on point. And then in Bridgewater is cited in Rozier, which is ROZIER.
Mr. Steele, can I ask you a question? No, it looks like I think it's going to be page 886. it's got, Bridgewater further challenges Davis' out-of-court statements to Thornton, as recounted by Thornton, arguing that the state failed to ask Davis any specific questions about those alleged statements and did not identify the substance of those statements. As a result, Bridgewater argues that he was never afforded an opportunity to explain or deny his prior consistent statements to Thornton, and the defense team was unable to interrogate Davis about them. And they cite 24-6-603, and they state that the appellate court states that we disagree. So how are you saying that's not applicable or potentially applicable here?
If you just go the next two sentences, specifically, Mr. Davis, the witness, denied ever making a statement to the police at all, and denied ever even knowing one of the parties.
Well, isn't that kind of similar what we have here in terms of Copeland saying, hey, I made up this stuff, or worse to that effect?
I think it's diametrically opposed, because Mr. Copeland's saying, I actually did say all this. His words, I believe, are, I probably did. I was making it up.
Well, I think he says that, but I think he also says I made up a lot of stuff just to get out of jail. So,
well, I think that is in concert. So they hold hands. I think the way I understood it, I'm not looking at a transcript. Mr. Copeland said, I probably did say that. I would do anything to get the authorities to take the target off me and put it onto someone else. That's how I understood basically the totality of his testimony. So he is not denying. Mr. Davis here said, I never spoke to the police. I never spoke with them. So that is a blanket denial that he said anything. He also said, I don't know this person. That is a blanket denial that he could talk about that person. So the state, in that case, in Bridgewater, did not have to go line by line, question by question, and say, well, didn't you say this? Here, I think we are jumping the curve and allowing the state, based upon their desire, I guess, not to lay a foundation the way I understand the law, and just say, well, he said, and the state keeps saying the same thing, and the court keeps saying that's not what he said. The state keeps saying, he said, I lied about everything.
that's what the state told me.
They keep telling the same thing day after day. That is not what the court heard. It's not what I heard. Where Attorney Adams, he's saying, shaking his head, yes. He's just explaining it. But if they want to get in a specific, like Shannon had the gun, Mr. Jackson, excuse me, had the gun, then I would also join Mr. Sharp and say that he needs to be given an opportunity to say, did you say this? And then he'll say, I assume, yes, I did say this. Why did you say it? Because I lied. And then you don't have to play the recording.
I'm going to ask you one other question. What say you about the extrinsic evidence argument from the state?
I think that it's specious. I think that, and I could give you the case right now, actually. I just have to flip my computer. What Mr. Shart said is right. This is not, yes, gun, if I possess a gun, there's no problem. I could possess a gun like I could possess this highlighter. It's not bad character. But Mr. Jackson, in this case, is a convicted felon before this June 10th, 2015 interview. So clearly that is a criminal activity. So I think that answered your question. So I do believe that it is the character, inappropriate character of Mr. Jackson.
Okay, thank you, sir. Anybody else? Okay, State?
Yes, Your Honor. So as it relates to the prior inconsistent.
Let's talk about Bridgewater first. What's your take on that?
So again, Your Honor, Bridgewater is a prior inconsistent statement case. We are at impeachment by contradiction. He says he made everything up. So there, even if he didn't say the word lying, he said, everything I said back in 2015, I made it all up so I can get out of jail. So now the jurors get to see what he said previously in order to determine if they believe him in court or if they believe him when he testified, when he talked to police back in 2015 that he made it all up. Second, so that's first and foremost, as it relates to my response to Bridgewater. We use it as an example of whether or not we have to go line by line, but for the same principle, if we're impeaching him by contradiction, we are saying what he told this jury in 2024 is contradicted by what he was doing in 2015. So that answers the first question as it relates to the Bridgewater analysis. And I think, and I would need Ms. Weaver to check, I believe when prior to the February 20th interview, before we started playing that interview, I thought I asked Mr. Copeland about what happened with the gun, but I would need to double check that. I don't want to say it, but I thought I asked him what did he do with the gun, and he denied giving it to Shannon, or he denied what his response was. But I would need to check the transcript for that.
What about the issue asserted by the defendants about Mr. Stillwell being a convicted felon? And because you cited a couple of cases for that particular proposition: Adams versus the state, Hill versus the state, and Williams versus the state. Johnson versus the state.
You're right.
Is that different because Mr. Stillwell is a convicted felon? I mean,
No, I don't believe so. And I was looking at another case, Hollis v. State.
Hollis, Hollis v.
Yes,
State?
Hollis v. State, to look at
What's Hollis?
359 Georgia App 249.
Is Georgia Appeals or Georgia?
Georgia Appeals 249. To see if in the facts of that case, if the defendant Hollis, I believe in that case, defendant Hollis may have been on probation for a crime and he had a gun, and the same proposition was the same, but I need to look back at the facts of those cases. And I'll wait till the court looks at Hollis. And I'm sorry, I believe it was an Adams case that he's on.
Can you give me the specific for that?
Sure, it's 318 Georgia 105. They're being answered, I think there's something else for probation. So I have not found a case out of one point. Speaking directly to the issue of Mr. Stillwell being on whether or not the fact that Mr. Stillwell being on probation would impugn his character, but Your Honor, the state will go back to the Johnson v. State case, which is about inextricably intertwined evidence, Your Honor. And again, not forgetting that the prosecution that's currently going on is not relegated only to the murder of Donovan Thomas. We are in a RICO conspiracy. And so the sole fact that Mr. Copeland, in the midst of a retaliatory shooting in which the opposition gang believes that he killed one of their gang members, uses a gun that was given to him by Shannon Stillwell, is one inextricably intertwined into this case. And although it's inextricably intertwined, and although it incidentally places his character although it places Mr. Stillwell's character at issue, it is inextricably intertwined into the overarching story and conspiracy that we are attempting to prove in this case, Your Honor. And here in the Johnson case specifically, this court let in an entire aggravated assault shooting as intrinsic evidence.
Is that Johnson at 312 Georgia 481?
Yes, 481.
Alright.
And interestingly enough, this case involves the Atlanta Blood Gang as well. But here, the court let in an entire aggravated assault shooting as intrinsic evidence.
But I think that, like, let me go back to Adams. I think Mr. Shart's argument is his specific grounds of objection are that his client is a convicted felon. So,
And so that's why the fallback plan, or not the fallback plan, but that's why if you think that that is a character issue, what Johnson v. State says is if an act is inextricably intertwined, one, it comes in, and then two, when I cited the court to Williams v. State, 302 Georgia 474, intrinsic evidence remains admissible even if it incidentally places the defendant's character at issue. So even if you believe that his character, which the state still contends that it is not, because it's intrinsic, even if it incidentally places the defendant's character at issue, it would still come in. This incident in which Mr. Copeland is now explaining to the investigators why he was unable to turn in this gun is inextricably intertwined into the series of events that occurred. Defense counsel has made it an issue that Mr. Copeland has been lying throughout this entire interview. So this gives a reason why he was unable to turn in that gun.
We haven't even crossed Mr. Copeland, so I don't know. I haven't called Mr. Copeland.
Mr. Steele's argument all last week is the reason why some other rumors are going to come in is because they want to show that Mr. Copeland lies in this interview. That was the exact argument last week as to why certain non-relevant portions of this interview should come in.
Ms. Hilton,
Mr. Shaw?
I'm just seeing if you were
Oh, yes.
finished. Okay. So, Your Honor, couple things I disagree with. First of all, this is not intrinsic. The state can say, oh, well, this is a RICO conspiracy. We are dealing with the January 10th, 2015 Donovan Thomas homicide, and that's allegedly what all this is related to, according to the state. But even if we took an expansive view, this indictment alleges, I should know the number, near 200 different overt acts. 191, okay? This February 20th shootout outside Kenneth Copeland's house is not one of the alleged acts. So we are now going into the minute details and collateral information about a act that isn't even among the 191 acts charged. Secondly, even if we were to label this as intrinsic, which I don't believe it is, the state said it's admissible as long as, even if it incidentally puts the character of the defendant at issue. This is more than incidentally.
Let me just engage in a little conversation. Ordinarily, you'd be right, but there's a background in terms of this gun that the jury's heard and is continuing to hear in this particular case. And that being is that in the interview, he says, well, Copeland, I was telling the police anything they want to hear because I want to get out of jail. I'm gonna go get that gun. This kind of fills in that particular narrative about about this particular gun. So it is kind of, is relevant, and it is kind of inextricably kind of intertwined in that respect. And,
Well, let me-
and it kind of in looking at Johnson at 370 at 312 Georgia 481. Evidence is admissible as intrinsic evidence when it is an uncharged offense arising from the same transaction or series of transactions charged offense. 2, necessary to complete the story of the crime. Or 3, inextricably intertwined with evidence regarding the charged offense. It's like Smith versus the state. So in this particular circumstance, I think that's why they're trying to complete the picture about the weapon.
I understand what.
Okay, and I know you fundamentally disagree, and
Well,
I'll take that.
Let me just say a couple things. First of all, this weapon, I think this is important to know. This gun is not involved allegedly in any other crimes or acts. So there's no loose ends that need to be tied up later with who had this gun or where was this gun. This gun, the story about this gun ends here. Okay, so there's nothing else that comes up about this gun. But secondly, when we're talking about, and this is why I said incidentally places character evidence. Okay, I've already distinguished my client is a convicted felon, it's character.
do you
But
have any case law that
this is
that
important.
specifically shows that, and you can invite me to look at
Uh,
about a convicted felon?
Well, I think it's pretty clear. I mean, evidence of someone committing an uncharged crime
Well,
is. But
I asked you if you had a case.
I can look.
So I could, I mean, that would help me kind of decide this, but it looks like from looking at Johnson, that even an uncharged offense, can be considered
I
for the proper
understand that.
purpose.
I understand that, but this is when we get to the level of prejudice and
And I have to I'll make a 403 balancing test in that respect, because you're absolutely right. I'm supposed to do that.
and I just want to point this out. Not only would the jurors be hearing about my client committing an uncharged crime, but the most important thing that I'd ask you to consider is my client, this uncharged crime, which they're going to hear about through a videotape of my client committing. My client is charged in this indictment with 2 counts of that exact crime. So they're going to hear a videotape of Kenneth Copeland talking about my client, Mr. Stillwell, committed possession of firearm by a convicted felon. They're not supposed to consider that for propensity, I guess. But then at the same time, they're going to be asked to weigh in on his guilt or innocence of 2 separate counts of possession of firearm by a convicted felon. To me, that increases the prejudice, because I mean, it's obvious if you were charged with check fraud and someone brought up that you pushed a lady down the stairs one time, yeah, that would be prejudicial. But if they bring up the fact, oh yeah, he's been convicted of, or he committed check fraud on this day and committed check fraud on that day, and then we say, hey jurors, what do you think about Mr. Stillwell? Do you think he's guilty of these check frauds? Of course, they're going to say yes, because they're going to have heard about these prior uncharged acts. So that's what I'm dealing with. The uncharged act is exactly what he's charged with in this indictment.
Okay.
And that increases the prejudice.
All right, you're saying just the fact that the state's trying to complete this. So you're saying the state's trying to complete this story about this weapon, and this weapon is not used in any way
There's no
in this
story.
particular case?
There's no story to complete about the weapon. The weapon is a dead end. Nothing happens with that weapon. I could see if this weapon was used in another crime and they need to track it. This weapon is not part of the story at all. It's not intrinsic. It's a dead end.
Well, I'll weigh that, but I think they're saying it's intrinsic to the fact of this completion of the weapon. I understand now. I understand your point is it's not really, it's not, this is not the gun that's charged with anything in this case.
Right, there's no ballistic matches.
All right, okay. State?
Your Honor, again, the state's intention is not to impugn that this gun was used in any other offense. It is solely to complete when Mr. Copeland says, I told you all I was going to turn in a gun. The gun that I was supposed to turn into you all, I did not turn it in because it was Shannon's gun. That is what we're trying to complete, because again, defense counsel will purport through whether it's their cross-examination, but what they have indicated is that they want to show that Mr. Copeland is a liar. Mr. Copeland is now explaining to the detectives, in February, I told you all I was going to give you a gun. I never gave you all a gun. Well, let me tell you in June why I didn't give you all the gun. I didn't give you the gun because it was Shannon's gun. And Shannon took the gun with him. And that's why I could not give it to you all.
But
There's a reason behind the gun.
But what it does is, nobody's been able to kind of tell me otherwise that being a convicted felon. I mean, I know it's a status offense, but.
But even looking at Johnson, Your Honor, the Johnson case in which they're allowing an intrinsic act of an aggravated assault, the case itself was a murder case. And they allowed into evidence another aggravated assault. It was a murder and a shooting incident at a gambling house.
Uncharged aggravated assault?
Yes, it was
the
an
one that was on charge in the indictment.
It was uncharged. It was uncharged in the indictment, and they allowed it an entire.
It was not charged in the indictment.
It was not charged in the indictment. So here, Your Honor, we're not asking for a crime to be admitted. We're asking solely for the playing of the fact that the gun was not turned in because it belonged to Shannon. Shannon went on tour with Thug, and he went to Miami. We're not even saying that.
Okay. All right. Let me say I buy that. What about Mr. Shart's argument about it? I have to do then a 403 balancing test. Is it more probative than prejudicial? He's saying you've already charged Mr. Stillwell with 2 counts of possession of firearm by a convicted felon, which are going to be brought up later on. He's saying this increases the prejudice. So what would you say about that? Because, and I'm listening to it because it's a road to nowhere. It's kind of like, in terms of what you have to prove, it kind of just, the jurors may think, well, this guy's who's a convicted felon has this gun and it's not really involved in anything that's charged in this case.
Your Honor, Mr. Stillwell is charged with a murder in 2022. And that's, I believe, one of the offenses that.
Okay, but is this gun tied to anything?
The gun is not tied, but trying.
Okay, that increases the prejudice though, because if it's not tied to anything, I mean, I understand what you're saying, but.
Sorry, I apologize.
No, go ahead. I'm apologizing.
No, you
ahead.
go. I'm sorry.
No, what it does is it increases the prejudice in terms of because you don't want the jury confused on the fact that, okay, we've heard Shannon's got a gun, or that Copeland's saying, hey, Shannon, the reason I didn't turn it in is because Shannon took it and he took it down he took it. But it doesn't go anywhere because it's not used in any other thing. It's not used in any other criminal offense. It's not tied to a murder. It's not tied to anything. It's just the fact that this shows where this gun went on a guy that's already who's a convicted felon, and it's not charged in the indictment. I know I could probably let it in, but my concern is Mr. Sharp's concern, and that's whether or not it's more prejudicial than probative, given everything that he's charged with. Is this going to confuse the jury or let them know, hey, what about this weapon when it's not tied to anything in the indictment? I mean, I know that Johnson seems to indicate that, but so tell me how I get over the 403, given what you charged Mr. Stillwell with in this indictment.
Sure, because the state has not asserted and will not assert that this gun that Mr. Copeland used in 2015 is the same gun used in 2022. It's a 7-year difference between this particular incident in 2015 And what Mr. Copeland says, the only purpose for this portion is to complete what happened with the gun, especially given this notion or this idea that in 2015, Mr. Copeland was just lying about everything. So we as the state have to show, we believe that in 2015, his statements were credible. He gave a reason for what happened with the gun. I believe that Mr. Sharp's trying to confuse issues as to the fact that Mr. Stillwell is charged in the indictment with possession of a gun. That is separate and apart from the purpose in which this particular piece of evidence will come in. It is solely to complete what happened with the gun that Mr. Copeland used in order to defend him, his child, and his child's mother. The state has no intention of saying this Glock was used in some other crime because we don't have any evidence towards that. Furthermore, when we talk about what happened in 2022, as the court will instruct the jury, they have to look at every crime individually. So when we get to 2022 and the murder that happened in 2022, the jury is going to have to look at the evidence for that particular crime, in addition with the RICO, independently of whether or not Mr. Copeland used this gun to fire back at individuals who were shooting at him. They're going to have to parse out that evidence for themselves.
That's a separate issue other than Mr. Stillwell. I hear what you're saying. I mean, I tell you what I'm going to do. I'm inclined to apply the 403 balancing test and find it's more prejudicial than probative. But here's the take, defense. If you open the door as to it, I'm gonna let them bring the truck. So you got to be very careful about not opening the door about this particular issue and this weapon, okay? Because if you open the door as to it, I agree with you, Mr. Sharp, Mr. Steele, that it is more prejudicial than probative. But if you dance around the issue and open it up, I'll revisit my decision. Okay?
Yes, Your Honor.
All right.
And then, Your Honor, can we then ask him if he gave the gun to someone? Because I believe that it is important that the jurors know something happened with this gun in which he expressed that to the officers back in 2015. I mean, not to say that it was Shannon, but to say that.
I think you get in the same issue about if you name Mr. Stillwell.
No, we're saying not to name him, but. And I don't know what Mr. Copeland's response will be in court today, or in court whenever he comes back. But to ask him specifically, did he give, without telling me who, did someone take that gun? I mean, because I believe that we have to there's a reason why that gun was never turned in.
Sure.
Your Honor, my concern is prejudice upon my client, Mr. Stillwell. So if Mr. Copeland is properly instructed beforehand to
not mention Mr. Stillwell's name or anybody else's name.
And he says the gun was taken and I was not able to retrieve it or whatever, then that solves my problem.
All right. Are you good with that? And I will I will just tell you that you will need to talk with Mr. Copeland about that. He needs to make very clear that he cannot mention Shannon or anybody else.
And again, given his current, how he's been testifying in court, we don't want to allude. I want him to give whatever answer he's going to give.
But I think you're going to have to tell him that the court has already ruled you cannot say it's Mr. Stillwell.
Okay.
I mean, I think I think that would be a proper witness admonition about that.
Yes.
Or you could lead him at that point in time.
All right, thank you, Your Honor.
So you do both of those two things just to make sure he doesn't get into anything that would be inappropriate, okay?
Yes, Your Honor. Thank you.
All right. Okay. Excuse me. Okay. All right. Moving on, I think the next thing that we have is 11:45:15 through 11:45:24, which corresponds with page 83, 183, lines 21 through 23.
Those are the state's redactions. So we can move forward. I think the next defense redactions are paid.
So are you going to redact those particular portions, or are you not sure? You got, I think under Mr. Sharp's table, it's got unsure.
We're not playing those. I'm not sure.
Okay, so you're not going to play those?
Yes, we're not
Okay.
playing those portions.
All right, so you're going to omit that, and you're also going to omit 11:48:25 through 11:48:34. And that corresponds with page 186, lines 20 through 22, correct?
Yes, Your Honor.
All right, so the next thing, Mr. Sharp, I think we have is page 188, line 9 to 189, line 9. Is that correct?
Yes, Your Honor.
Mr. Sharp? I think that's what you, I think that's what you all have identified. And your comment is commenting about Shannon doing everything for Thug for free, or worse to that effect. So you want to flesh that out?
Yes, Your Honor. I don't know what Mr. Copeland is specifically referring to when he makes these very generalized statements. But he essentially just goes on to say that my client doesn't have many earthly possessions, which I don't have a problem with him saying that. But he also insinuates that he commits crimes for Jeffery Williams and doesn't get paid to do so. He just does it to do it. He doesn't give specifics. I'm not sure what he's referring to, and it's bad character evidence, violates 404A and B. And that's why I'm objecting. And I don't know, it's entirely unclear what his personal knowledge to any of this is.
All right, sir. Ms. Hilton? Yes, ma'am. Okay, go ahead. And then what's that, what's the reference on the tape?
So the 11:50, we'll start a little before 11:50:01 to 11:51:03.
All right.
Young Thug RICO. Whatever he say, you get paid? Nothing. There's no way. There's no fucking way. It's my mom graveyard. Why? Why he doing it?
He that guy.
Guess told me he wasn't getting paid next. So. Wait a minute, what?
He said Shannon. Shannon told me. But why at the time Shannon don't trust you, why would I tell you anything?
Okay, put it this way. He ain't got to say that. What does he got? Shannon got a truck. He gonna take you for $2,000 to get his truck back. He ain't got $3,000 to go take him. You know what I mean? The shit out here, man. I know Shannon. So like I got to and say, now wait, come on, man. You right, I don't have to do it. You know what I mean? I don't have to say that you ain't got shit, boy, but you.
Okay, what's the state's theory of admissibility as to that respect?
Your
That
Honor,
particular line, those particular lines.
one, I don't believe that it's character evidence at all. When we start this portion, prior to this particular section, they begin talking about why the opposition was targeting him first, and him being why the opposition was targeting Mr. Copeland first after the murder of Mr. Donovan Thomas Jr. And he's explaining, he being Mr. Copeland, is explaining that it's not me, it's Shannon. And he doesn't say his name. That's when he points to the paper. Because it would appear that on the paper, Shannon's name is on the paper. And he says, this is your problem right here. Whatever he says, he does. And he points to the paper. Presumably, Mr. Williams' name is on the paper and Mr. Stillwell's name is on the paper. They then go in to ask him, how much is he getting paid? He says he's not getting anything. And then they ask him, well, who told you that? And he says, he points, what I believe to be, he points at Shannon, because Dennis clarifies, he says Shannon. Shannon, he says Shannon. So one, this goes into Copeland's belief of why he doesn't understand why he's being targeted by If Gang, because I'm not
He being Copeland?
correct. And he's explaining that I'm not the problem. It's Shannon is the issue. And they're trying to understand more of the dynamic or the relationship between Shannon and Mr. Williams. And he further explains, look, he's not getting paid. He does, according to Copeland, he's doing whatever he wants just for him. And I believe that, again, that is
He being Mr. Stillwell?
correct, is doing whatever it is that Mr. Stillwell is doing for Mr. Williams and not getting paid for it. And not, and so I think, again, that is important when we talk about this gang RICO enterprise, the relationship between the parties. And what Mr. Copeland is talking about is the relationship between his perception of the relationship between Mr. Stillwell and Mr. Williams. And again, when we're talking about the larger conspiracy and we're talking about the nature of their relationship, the nature of the enterprise, here is arguably an unindicted co-conspirator to the larger gang talking about two other gang members and the relationship between them. We believe that that is relevant for the jury to hear.
John, I'm gonna withdraw my objection.
Okay. Mr. Steele?
Well, I'm objecting to everything, but.
Of course. All right. I just wondered if you have another specific objection since it references your client. That's why I was asking you.
I have objections that believe the court noted. I know Shannon, that's his response. How do you know this information? I know Shannon. He doesn't give any background reason. The state hasn't asked about this at all. And then Mr. Copeland just pontificates and speculates how did Shannon get $3,000. He has no idea. So all of that is wrong. With that being said, though, I don't want to go against Mr. Strike, really, target this.
Okay. I've noted your objection. I'll allow the state to play it over your objection. I'll give you a continuing objection. And that is page 188, line 9 through 189, line 9 or thereabouts. Okay? All right, next, I think you all have page 196, line 16 through 199, line 4. And that talks about Mr. Stillwell and D shooting up houses, about how Mr. Copeland lacks any firsthand knowledge, and might be talking about the wrong story.
And Your Honor, this is page 197 to 198.
Page 197?
Yes, I think we will start at page 197, line 17, and it actually goes to page 199, line 4, and the state has no objection to redacting that portion.
Ms. Hilton, I appreciate that. The way I read the conversation, I'm seeing it begin on 196, actually line 1. About D being dropped off at the club. And now, admittedly, D being dropped off at the club is the part of this that concerns me. But I just wasn't sure if you wanted to take out any mention of anything or. I think it all involves the same event.
No, we believe that it's important up until line 121. Excuse me, line 20. Line 17.
I would say definitely we need to start on 14, 197, line 14. Where, you know what I'm saying? So anyway, what I heard was.
Your Honor, we can redact beginning at line 14.
From page 197?
Yes, page 197.
To,
After the period, after Big Brother.
so you redact after that?
Yes.
Through page 199, line 4?
Yes,
Mr. Short, you good with that? Anybody else have any objection or wish to be heard about those lines? Okay. All right, Mr. Steele. Anybody else? Okay. All right. Next is page 202, line 5 through 202, line 19. Before we go back there, Ms. Hilton, can you give us the transcript page, the tape references for 197, line 14 through 199, line 4?
Yes, Your Honor.
Okay.
It's going to be around 11:57 and 22
To,
to 11:58 29.
All right, thank you, madam. All right, going back to the next one, page 202, line 5 through page 202, line 19. And I believe that that is comments about Mr. Stillwell carrying a firearm.
You're given the court's current ruling, we would like it in, but we understand the court's previous ruling.
Okay.
And so I think that would be consistent with his previous.
All right,
ruling.
I'll omit that. Any objection, Mr. Sharp?
No,
Okay, all right, I'll omit that. All right, the next one is page 213, line 20 through 214, line 16. And I believe that that goes to hearsay. Involving, I'm sorry, go ahead now, involving the Dexter Montgomery shooting.
For one moment, Sean.
Yes, ma'am.
I'm sorry about that. Thank you, Your Honor.
Okay, the page 213, line 20 to 214, line 16 is hearsay involving Dexter Montgomery shooting. So.
And I can play it for the court, Sean.
Okay,
It'll be from page 213, line 23 through page 214, line 18. And it's gonna be 12-10-51 to
12-10-51.
to 12-11-33.
All right, okay. Go ahead and play it, please, Mal.
It's gonna start a little earlier at 12-10-48.
Yes, ma'am.
They were talking about damn Wayne Buzz. I know OG Bentley shot the boy in the head over there. No, you didn't. Who shot? DK? Nah, this ain't know it. No, I knew. The two people got caught with sticks. Yeah, no, DK. And why did not shoot him? I don't know. They just need your details. I mean, they just like, no, without me, they don't have a question on the record. I'm like, wait a minute. I was thinking I killed that gas station in Lakewood. I mean, like that. So, but how do you know Nar did it? D? How do you know Nar did it? Says you been in trouble. They talk about it. I mean, like I tell you, yes, what it was.
And we're stopping at 12-11-34.
All right, State, you want to tell me, go ahead. Go ahead.
I was just gonna point out that in this, we've heard testimony about that incident. Mr. Copeland, no one said he was there. He obviously wasn't there. He says his source of information when he was talking to the police was D. I take that to mean there's two Ds. I take that to mean Lil D, meaning Demekion Garlington.
But we don't know.
We don't know for certain. It could also be Quindarius Zachary or another D, but if it's any of those people, none of the people that were there are known as Lil D or D. So he got it from someone who must have got it from somewhere else. And so we're just kind of rehashing rumor and hearsay.
All right, sir. State?
And Your Honor, we should start with page 23, page 213, line 23. The reason that they even get into a conversation about the Dexter Montgomery shooting is Detective Gates. Let me say this, but let's get to context. This interview is in June of 2015. The police don't know the full details of the Dexter Montgomery shooting till about July of 2015 and August of 2015. And that is, if you can recall, Your Honor, that is when Walter Murphy was interviewed, both in July and August of 2015. So in June, they don't know the full details of what occurred. So Detective Gaither in the line right before this says, I know OG Bentley shot the boy in the head over there, talking about the Dexter Montgomery shooting. And Kenneth corrects her and says, no, he didn't. And she said, who shot him? And he says, they're saying Nard. Nard who? Because two people got out the car with sticks. And he's confirming Nard and DK. And he says, then why did Nard shoot him? I don't know. This is what Dee's telling me. I believe he's talking about Deamonte because either earlier in the interview or later in the interview, he says he gets a lot of his information from Deamonte. He says, you know what I mean? They just like Nard went down, Bentley went down for a question on a murder, and I was like, what murder? And some nigga got killed at the gas station in Lakewood. You know what I mean? Like that. And then they go in, but how do you know Nard did it? Said D. The reason why we believe that this is important, one, the evidence about the Dexter Montgomery shooting has already come in. The jury has heard that. They heard that over a course of a few weeks back, I think now in April of this year. The reason why this is important, again, Mr. Copeland saying everything he said, he was making it all up. One, this shows that he had knowledge of this gang's activity in 2015. And he's disclosing that information that he knew back in 2015 in this interview. And if the assertion is Mr. Copeland is lying throughout this entire interview, which is what defense counsel has purported or said that they plan on impeaching him on, this shows, one, he's not lying. Two, he knows how to correct inconsistencies or things that are incorrect. And it shows, it gives even more credibility to Mr. Copeland back in 2015 when he's giving information specifically about what happened the night of Donovan Thomas's murder. So we believe that the jurors can see from Mr. Copeland's ability to, one, correct the law enforcement officers, two, advise what he knows of the gang's activity is relevant for this jury to assess his credibility, Your Honor.
Your Honor, the fact remains it's still hearsay, and nothing that the state said is a hearsay exception.
Yeah. State, I'm in concurrence. It's still hearsay with no exception. So I'm going to omit that particular portion. From 213 line 23 through 214 line 18, 12:10:51 through 12:11:33. Okay, the next one is page 220, line 11 through 220, line 21. And I want to say that pertains to purportedly bad character, Mr. Stillwell punching somebody else's baby's mama.
Your Honor, the state, I believe the correct lines are page 220, lines 12 to 15, which is 12:15:50 through 12:15:56.
12:15, I'm sorry.
12:15:50
Uh-huh.
to 12:15:56.
Okay.
And we don't have any objection.
You're gonna, okay, all right.
And I agree that there are times covered what I was concerned.
Okay, all right. So that's covered. The next period is 222, line 17 through 223, line 6. And that purportedly shows some hearsay in regards to beef with Game and Nipsey Hussle and the squashing of this purported situation. Mr. Sharp, you want to say it? You want to flesh that out?
I have no indication that Mr. Copeland knows or has ever been around the Game, who I believe his government name is Jason Taylor, or Mr. Nipsey Hussle, who's now deceased. But it's certainly a story that he tells that I think there's internet rumors and speculation and everything else, but there's no indication that this is based on personal knowledge, anything more than me Googling street rumors and then saying this is what happened. So there's no personal knowledge. It should not come in. It's hearsay. And it's speculation.
All right, Ms. Hilton.
Yeah, I'll play the section.
Okay.
And we're gonna start a little earlier at 12:16:59, but the relevant portions will begin at 12:17:08.
You said what, I'm sorry, one more time about the
We're starting earlier at 12:16:59, but the relevant
12:16:59,
but the relevant portions will begin at 12:17:08
and you're gonna play through.
through 12:17:31.
All right, thank you. Okay, go ahead.
Nobody care about nobody. You know what I'm saying? Don't take shit from nobody.
How does the beef with Game in here?
The game league is shout out to Doug with told Shannon do it. Shannon told me smile you saw that win.
Just give me the word.
Yep. And Doug told him no. Say something on the GD, I can't Nipsey, Nipsey Hussle, something like that. He ain't the beef. You know what I'm saying? He stopped. You know what I mean? I ain't here to play. You know what I mean? I just don't want to go to jail.
And we stopped it at 12:17:35. And so what we have here, Your Honor, is actually two party opponent admissions. So Detective Dennis asks, well, how is the beef with Game and them? And Copeland says, well, the Game was fixing to get shot up if Thug would have told Shannon to do it. Shannon told me out of his own mouth, he was up there waiting. Just give me the word. Yep, and Thug told him no. Said talking to him, GD, I can't really say like Nipsey Hussle or some shit like that. He ended their beef. You feel what I'm saying? He stopped it. You know what I mean? I ain't here to play. And Your Honor, if you can recall, we already have in evidence the video of Mr. Stillwell in the car threatening the Game that has already been introduced. So this is further corroboration of that video that has already been entered into evidence. And Copeland saying that Shannon was ready to act on behalf of the gang for Mr. Williams, if Mr. Williams would have gave him the go ahead, but Mr. Williams told him not to do it. Sure.
Yeah, sure, absolutely.
How does the beef with Game in here?
The game league is shout out to Doug with told Shannon do it. Shannon told me smile you saw that win.
Just give me the word.
Yep. And Doug told him no. Say something on the GD, I can't Nipsey, gets a hearse or something like that, he ended you. You know what I'm saying? He stopped. So I mean, I ain't here to play. You know what I mean?
And we concluded the playing again at 12:17:34.
All right, Mr. Sharp.
I don't hear exactly what, Miss Hilton hears. I can't say I hear something different. I can't make out where she's saying that Shannon or that Kenneth told me out of his mouth. But it's hearsay unless we can identify the source of his knowledge and it falls under a hearsay exception. I don't believe that this statement does that. I believe that he's speculating based on what he's heard from, as I said, from the internet or rumors or street rumors. But the other thing I'll say, it's also not an admission by a party opponent in and of itself. And that's because the hearsay that I'm concerned with is Kenneth Copeland's hearsay. And he's not a party opponent. This is hearsay. And this never came up at all, to my recollection, in direct examination of Kenneth Copeland. So there's been absolutely no foundation laid.
What about the earlier video with your purported your client?
Well, that was
Talking in the car about, hey, I think this is the one of,
that was admitted over my objection.
yes.
And my objection to that is still the same, and I guess I should probably reiterate that as well. This alleged incident involving the game is not charged as an overt act. There's no police reports in the discovery, to my knowledge, is just this video with nothing else. So there's really no, I know that the state wants to take a very expansive view of what a RICO prosecution is, but again, they named 191 overt acts. Nothing involving the gang was named in the indictment, and there's no police reports regarding threats to the game or anything else. There's just this one video that's pulled off of some website somewhere and thrown into discovery. And I don't believe that it's intrinsic to anything, and I don't believe it's relevant. Now, obviously, Your Honor has disagreed with me, and Your Honor let in over my objection the video, but just because that has occurred doesn't mean that I agree that other conversation and hearsay conversation by Mr. Copeland should be bootstrapped into this trial just because we've admitted one video over my objection.
Yes, sir. Okay. Ms. Holton?
Your Honor, again, this is corroboration of the overall conspiracy of the gang. Your Honor, I think that sometimes maybe we stream away from, there's still an overarching conspiracy of the gang itself and the activities that the gang does. And so the court, even over objection, admitted evidence of Mr. Stillwell threatening the gang on video. Here, Mr. Copeland, and this says, and we can play it again for the court, Shannon told me out of his mouth. So that is
What line is that?
this would be
Page.
line 20 on 222, but where it says indiscernible, if you actually listen to what he says, and I'll play it again.
Play that portion, just that portion
Yes.
again. Hold on.
I went too far. I'm going to start it at 12:17:06. Oh, sorry.
nobody else. You know what I'm saying? Thug ain't taking shit from nobody.
Well, how did the beef with Gang then?
The game nigga did shut up and Thug would told Shannon do it. Shannon told me his mother was up there winning.
Just give me the word.
Yep.
And I can play it again.
The game nigga did shut up and Thug would told Shannon do it. Shannon told me his mother was up there winning.
He said Shannon told me out of his mouth he was up there waiting. Prior to that, he says the game was 50 and shot up, and if Thug would have told Shannon to do it.
Christian, Chris, can I listen to your? I'm gonna see if I can hear it from Miss Weaver's vantage point. And I'll invite anybody else to listen to it. You just hear.
Let's do it on the table.
Huh? Yeah. I'm gonna listen to it first, Mr. Adams, and let me just see whether or not I can hear it. If I can't hear it, it's no sense in you listening to it. Okay?
I'm gonna start at 12:17.
You're not ready.
Oh, not ready yet, okay.
Working last time.
Of course.
Oh, wait.
All right, you can play it now.
Well, how did the beef with Gang then?
The game nigga did shut up and Thug would told Shannon do it. Shannon told me his mother was up there winning.
Just give me the word.
Yep. And Thug told him no. Say something on.
Keep on going. You wanna keep going?
No, Mr. Adams, you want me to listen to it?
You hear better?
Yeah. I think he's, at least from what I hear, he says, Doug told Shannon to do it. So go ahead and listen to it. Any other counselor you want to come and listen to it, you're welcome to do so.
And I don't believe that, I think he said if Thug would've, they were about to get the ass shot up if Thug would've told Shannon to do it. Shannon told me out of his mouth, he was up there waiting, and then Dennis was like, just give me the word, give me the word. That, and Thug told him no, so I want to be clear. I think Mr. Williams told him no, but he was prepared to go. I'm gonna start at 12:17:05.
You know that.
Well, how did the beef with Gang then?
The game nigga did shut up and Thug would told Shannon do it. Shannon told me his mother was up there winning.
Just give me the word.
Yep. And Thug told him no. Say something on the GD. I can't Nipsey Hussey, something like that. He ended beef. You know what I'm saying? He stopped.
Stop at 12:17:31.
Hold on a second, Sarah.
Stop at 12:17:31.
Can I listen to it one more time?
Easy to listen. You know, hear the.
Mr. one more time, please.
I'm gonna play it, start at 12:17:06.
Well, how did the beef with Game in?
The game lead is Shannon is doing what told Shannon do it. Shannon told me his mother use up that wing.
Just give me the word.
Yep. And throw it to him, no, say turn on the GD, I think Nipson Hurst or something like that. He ain't baby. You know what I'm saying? He stopped.
Stop at 12.
I think it's, all right, this is what I hear. Shannon says I was up there waiting. One more time?
Can you turn it on?
Turn it down. It's working a little bit. Go ahead, one more time.
All right, I'm gonna start again at 12:17:06.
Well, how did the beef with Game in?
The game lead is Shannon is doing what told Shannon do it. Shannon told me his mother use up that wing.
Just give me the word.
Yep. And throw it to him, no, say turn on the GD, I think Nipson Hurst or something like that. He ain't baby. You know what I'm saying? He stopped.
One more time. It started a little bit earlier at 12:17.
Still ain't take shit from nobody.
Well, how did the beef with Game in?
The game lead is Shannon is doing what told Shannon do it. Shannon told me his mother use up that wing.
Just give me the word.
Yep. And throw it to him. Do it. Shannon told me his mother use up that wing.
Just give me the word.
Yep. And throw it to him, no, say turn on. Shannon told me his mother use up that wing.
Just give me the word.
Yep. And throw it to him, no, say turn on.
One more time, please.
Shit from nobody.
Well, how did the beef with Game in?
The game lead is Shannon is doing what told Shannon do it. Shannon told me his mother use up that wing.
Just give me the word.
Yep. And throw it to him, no, say turn on the GD, I think Nipson Hurst or something like that. Yep. And throw it to him. The game lead is Shannon is doing what told Shannon do it. Shannon told me his mother use up that wing.
Well, how did the beef with Game in?
The game lead is Shannon is doing what told Shannon do it. Shannon told me his mother use up that wing.
Well, how did the beef with Game in?
The game lead is Shannon is doing what told Shannon do it. Shannon told me his mother use up that wing.
Only thing I
Just give me the word.
up there
Yep.
is the last part, that last sentence. I can't hear the first part.
And I don't hear what the state's saying, and I don't even hear enough syllables to get to what the state's saying. I will stress the obvious, which is in a indictment where an overt act alleged is the shooting of a high profile hip hop entertainer's tour bus is included. This statement, the admission of this statement is highly prejudicial against my client. I don't hear anything in the statement that cures the hearsay aspect of this statement. And I still say that Mr. Copeland is giving information. The end of this, by the way, the end of this statement is, I want to get out of jail. That's how he ends this, right when the state's turning it off. He says, I want to get out of jail. He's giving all sorts of information that he knows, but he's not a lawyer. He's not limiting it to personal knowledge, and he's passing on hearsay that he thinks he knows, I should say, and it shouldn't be admitted for that reason.
Mr. Adams, what were you gonna say, sir?
Just to add to the record, I will say that listening to that the number of times I've listened to it, I did not hear what the state says that they heard it.
I didn't hear it either. All I can hear is that last little bit.
Yeah, I'll tell you that I heard one of two things. Either Shannon and them was on Metropolitan waiting for him, or Shannon was probably up there waiting.
That's what I thought I heard, but I can't be certain. I can't be certain because because I can't hear the first part of it.
But I'll tell you, I'm not 100% certain of it's one of those two. I know I didn't hear the state said they heard. He came out. Shannon told me out of his own mouth. I didn't hear that.
You're right, and I can play it again, but if you read it in context, that's what makes sense. Literally says
But
the game.
I gotta be able to hear it.
Yeah, and I'll play it again, but this is the context of it. The game was fixing to get his ass shot up if Thug would have told Shannon to do it. Shannon told me and I'll play it again, out of his mouth, he was up there waiting. And Dennis responds, just give me the word. Copeland says, yep. And Thug told him no. So when you read that in context, that is the only thing that he would have said is Shannon told me that he was waiting for him. And we can play it one more time.
That's the only thing. The only word that could have been said. And again, I think he didn't hear. Nowhere do I hear out of his own.
Metropolitan, but we can play it again.
All right, so let me hear whether or not I hear out of his mouth or Shannon something Metropolitan waiting for him. Okay.
Can you slow it down? Maybe we can slow that down.
The slowest it goes is 1.6. We were trying to see if it goes to 0.5, but it doesn't go slower.
The game lead is shout out to Thug with told Shannon do it. Shannon told me his mouth he was up there winning.
Why does it beef with game then?
The game lead is shout out to Thug with told Shannon do it. Shannon told me his mouth he was up there winning. Thug with told Shannon do it. Shannon told me his mouth he was up there winning.
Just give me the word.
Shannon told me his mouth he was up there winning. Told Shannon do it. Shannon told me his mouth he was up there winning. Do it. Shannon told me his mouth he was up there winning.
Just give me the word.
Shannon told me his mouth he was up there winning.
Just give me the word.
Yep. And Thug told him no. Say turn on. Shannon told me his mouth he was up there winning.
Just give me the word.
Yep. And Thug told him no. Say turn on the GD. I can't Nipsey.
Oh yeah. Miss Weaver has told me, authorized for me to tell you that you see how difficult her job is. Okay, so I'll be honest with you. I don't, Miss Hilton, I do not hear out of his mouth anywhere. But I have to be honest and say I don't hear. I get beat. I like Mr. Adams. I get little bits and pieces of Shannon, and then waiting for him. I don't get like that, the rest of that sentence that fills in. I can't hear it, or at least not now. Okay. All right. Thanks for y'all indulging and letting me hear it a bunch of times. Okay, in considering line 220, I should say page 222, line 17 to 223, line 6, and corresponding audio video portion 12:16:59 through 12:17:35 in regards to this beef with Game and Nipsey Hussle squashing it. Okay, the defense's contention is that there's no personal knowledge. It's hearsay and they believe it's speculation. And then the state asserts that these are two admissions by party opponents and it corroborates the prior discussions and gives overarching relevant testimony on the conspiracy of the gang and its activities. The court's in concurrence with the state's assessment, so I'm going to allow it over objection. I'll note, Mr. Sharp and others, it will be a continuing objection.
And Your Honor, just for the record, also, I objected based on lack of foundation.
Yes, sir. Yeah, I will add that as well, that you did object as to lack of foundation. Okay, all right. I want to say the next statement is page 230, line 20 through 233, line 4. And then it's page 234, line 19 through to 238, line 25.
Your Honor, could we have 5 minutes before you go on to the next?
Yes,
Thank you.
yes. We'll be in recess for the next 5 minutes, okay? All right. All right, councils, I think when we left off, we were about to discuss page 230, lines 20 through 233, line 4, and page 234, line 19 through 238, line 25. Okay, we ready? All right. So, I believe that's hearsay in regards to the Lil Wayne bus shooting. So where are we, councils?
Your Honor, the state has. The state has. We would like in to complete the thoughts on page 230 up to line 23. Because I think defense counsel starts at 230, line 20.
You said 230 up through line 23?
Yeah, so we want all of up to line 23 in, and then starting at line 24, we don't object from 230, line 24, and we had actually initially to 233, line 24.
All right. So, Mr. Short or others, you, Mr. Steele, any other, the state wishes to just, they want to play, they want to play up until 230 what, madam? 230 line,
So 230, line, starting the redaction at 230, line 24.
you want to,
I don't have any problem with that.
okay, going through 233 line 4?
Going through. Going to 233, line 24.
I don't have any problem with that.
So going to 230, page 233 line 24.
Yes.
All right, and what transcript, or I should say, I'm sorry, what audio, video portion does that correspond to?
It's going to be, and I'll just need to confirm, around 1223, probably around 40,
Okay,
but I'll need to double check it until 1226:08.
all right. All right, what about page 234, line 19 through 238, line 25?
no objection from course indulgence. No objection from 234, line 19 through 238, line 25.
May I make a suggestion? I'm in agreement with everything the state has said. It leaves this patch between 234 line 4, 233 line 4 and 234 line 19. Excuse me, let me try that one more time. It leaves a patch 233 line 25 to 234 line 18, which is about 18 lines, and it's just completely out of context without any relevant information one way or another. So I would suggest we just redact from 230 line 23 all the way to 238 line 25.
Okay. That's fine, Your Honor.
So what are the redactions to, madam? I'm sorry.
So I think we're really starting back at 230, line 23.
To,
Through 238, line 25. And that's going to be 1223, so approximately 40 to 1230. I think it's going to be 15.
okay. All right, Mr. Short, I think the next and others, I think that the next period that the state is going to. Are you admitting this, Ms. Hilton? That's 12/25/30 to 12/25/36.
So Your Honor, those two are all inclusive of what we just discussed.
Okay, all right, so we don't need to worry about those anymore, okay? All right, what about the the 241 line 3 to 242 line 21? And then I've got 243, I guess, pages 243 to 248, line 11. And then it's okay. So let's talk about those next. Yeah, Mr. Shaw, I think you've got discussion about not relevant matters.
Right. So, as known, Mr. Copeland tends to jump from topic to topic sometimes, and 242 towards the bottom of the page, 241, he starts talking about how the owners of Club Lacora thought that he had shot at the club or into the club, and it was one of Pee Wee Longway's people that had actually done it. And it's a big story about how he had to prove to the Allison brothers that he wasn't the one who shot, and it was proven by videotape that he was wearing some other types of clothes. And then he also talks about Tick robbing Bentley for a necklace. So that's all mentioned in the first part of what I would like excluded.
That's the 241.3 to 242.21.
Yes, sir.
All right, let me hear from the state.
From 241.3 through 242.21.
Yes.
So, Your Honor, we would agree from page 241, line 3 to page 242, line 18.
Okay. What's your stance on that, Mr. Sharp?
Well, the problem is, in there is a small area where Mr. Copeland and the detectives start talking about loyalty and how he's loyal to his friends and how these other guys weren't raised the same way he was. But then they immediately you know, after 5 lines or so, they start going into Bentley. He says Thug got his necklace back.
Yeah, I think that that's all part of what they're not gonna play. They're saying they want to stop it at 18 as opposed to 21.
Right, but then it picks up again, the second part of,
And that's 243.
right, and then they're talking about Thug going to what's the name spot with a whole bunch of choppers. And got his gun, got his necklace, and then they're back on the Allison brothers, talking about the Allison brothers, and then he's back on the topic of shooting up LaCoura again on 244. So, you know, there's a couple lines, I guess, that could be played. The bottom of 242, the beginning of 243, but again, it's kind of like the last one. They're sandwiched in between two sections that I feel should not be played, and I don't know, standing alone, how much context or value they have.
Okay, anything else, sir? I'm gonna get the state's,
No, that's it. I guess I need to hear what the state's view on the second part is, and then we can figure out if there's any use of keeping that little bit in the middle.
okay, all right. Ms. Hilton, what's the state's theory of playing 243 to 248?
I'm sorry, I didn't realize we were on 243, 248. I thought we were still on the decision regarding.
Can you turn your mic on?
Decision rather, in regards to 18 versus 21?
Correct, because I don't think,
Let's see if we can get to the other one then, is I think the defense is going to go back to that.
but
whether or
from
not
243 line 9 through 250,
You said 243 line 9 to what?
from 243, from 243 line 9 through 257. Well, let me start here. From 243 line 9 through 248, the state has no objection to.
To the end, so 248 through line 24? I guess that's the end of the page, right?
Yeah, so 243 line 9 through 248 line 24, the state has no objection to.
Okay, all right. Okay, then what did you have some other lines that you didn't have any, or you wanted to also say you were gonna omit?
Course indulgence for one
Yes, ma'am.
moment.
So Ms. Hill,
Yes, sir.
the question I was posing earlier was, between 242 line 22 and 243 line 8, does that make any sense in isolation, or should that be redacted?
So I was still wanting 242 line 15 through 243 line 7.
You said 242 what, ma'am?
Line 15 through 243, line 8. I'm sorry.
And that's fine, Your Honor.
All right. Okay, all right. Anybody else having discussion or objection as to those pages, 241, 3 to 242? Okay, all right, sir, thank you. Okay, what about, all right, so continuing, Ms. Hilton, from 248.
By changing it, I suggested 248, line 11, the state put forward line 24.
Yeah, okay,
And that chops off the first half of the conversation regarding Shell Cal and Tay shooting each other. I don't have a strong opinion about whether it comes in or not, but I would suggest if we're gonna take it out, we should just take out the second part of that conversation. If we're gonna leave it in, we should leave in the first part of the conversation. I think it's all hearsay, so.
Your Honor, the state Has no objection, redacted from 243 line 9 through 256 line 7.
All right.
That seems appropriate on behalf of Mr. Stillwell.
All right. Okay, then the next period we need to discuss is 266, lines 10 through 24, where there's some hearsay about Mr. Copeland and Mr. Williams and this apparent gun buyback.
Right. So this is regarding the gun that was left at the rec center, I believe. And Mr. Copeland says, I heard that Thug was told Lil D go back and get the gun, like from Indiscernible, you feel me? That's 266 line 10. And so what what he's saying to the detectives is that the plan, to his understanding through hearsay, was that Thug, Mr. Williams, instructed Quindarius Zachary to try to go buy that gun back from Kenneth Copeland, the assault rifle. So in Kenneth Copeland's own words, it's something that he has heard. I don't know. It doesn't appear that he was a party to any negotiations or anything like that. That's just something he heard, and that's hearsay.
All right. Ms. Hilton?
Your Honor, we're in agreement of page 266, line 10 through 13. Which is the portion, Mr. Shard is still page 266, but the portion which he does say, I heard, is page 266, line 10 through 13.
And I don't have a problem with that, except on 266, line 23, he goes back to repeating the hearsay.
You should listen to that portion, so he's repeating.
I can't understand.
Well, he said, so Thug was like, go get that gun, feel me. And he's already identified that his source of knowledge of Mr. Williams supposedly ordering to go get that gun was hearsay, so seems like we would take that out. I don't have a problem with leaving the rest in from 14 to 23, except for that line.
I'll play a portion. We believe this could be categorized as co-conspirator hearsay as well.
Are you talking about from 13 through 24?
Yes, 13 through 20, yes, 13 through.
Because you're agreeing that 10 through 13 should be omitted on page 266, but you want to play, I guess, 14 through 24. Is that correct?
Yes, Your Honor, but we do, I mean, now when you're looking at it all, 10 through 24, I believe we be co-conspirator hearsay, but given that we just told the court, we could omit 10 through 13, we'll play 14 through 24.
All right, let me hear that then. And what transcript, I should say, video transcript references does that go to?
It's gonna be about 12, 51, 13.
To,
To around 12, 21, 30.
you said 12, 51, 13 to 12.
51, 30.
Okay, thank you. All right.
It's gonna start a little bit earlier, around 12:50.
Yes, ma'am.
I should have that nigga right there. Should have. I ain't gonna lie, man. But really, at that point, it really worked because it was kind of still yours. Have you got your money yet? Huh? Because they were gonna pay time. Right? It's what I did here. I heard it. Oh, so legit go and get it done. Like from the front. You hear? Somebody see that what I'm saying? Like every time I happen, they call it good. Huh?
Yeah.
Yeah. So every time I happen, somebody call it good, says good. So do it like you go get the gun. Yeah. So that's what I'm saying. If you came in.
I had 12:51, 31. Brian, we'll admit, we will omit from 12:51, excuse me, page 266, 10 through 23.
Through 23? So it'll pick up at, you feel me? On page,
Yes.
on page 266?
Yes.
All right. Mr. Sharp, anything further?
No, thanks.
Anybody else? Okay.
On behalf of Mr. Wood.
All right, Mr. Steele. Okay, okay, I've got 270 pages, page 270, lines 11 through 21.
We believe that portion comes in, it talks about Shannon having possession of his chopper while Mr. Copeland was in custody. But given the court's earlier ruling regarding mention of Mr. Copeland, Mr. Stillwell, even possessing a gun, he would fall to that same category. We believe
believe it comes in.
All right, so you're gonna, you disagree or I'll admit it over your objection, okay? And what transcript, or I should say video portions that, include?
On page 270.
No, I got the transcript. What audio video does that include?
That would include 12:54:14.
Okay,
Through 12:54:30.
all right. Okay. The next one is, page 275, line 4 through 276, page 276, line 15. And that supposedly is a reference to hearsay about Little D, Deamonte and Garlington setting up someone to get robbed.
It appears to be hearsay, Your Honor, but it's also about some robbery or alleged robbery that I know nothing about and there's nothing in the discovery about, and I believe it's wholly unrelated to this situation. So it's not relevant and it's also based on hearsay.
Your Honor, we got that page 275, line 1 through page 276, line 14.
Yes, ma'am.
And we have no objection.
Okay. Can you give me the audio visual references as well this time?
12:58 to 12:59.
Said 12:59:24?
Yes.
Okay, all right. All right, anything else in regards to these pages? Mr. Charter, Mr. Steele, or anybody else?
No, Your Honor.
Oh.
On behalf of, not on behalf of.
All right, sir. Okay, okay, the next page I think I have is page 304, line 20 to 305, page 305, line 8. And that's an officer talking about talk about Officer BB.
And Your Honor, I believe last name was Robinson. He's referred to as Officer BB. This is the officer who there was some litigation earlier about possibly not being on the up and up. And I believe that where we are right now, we're not getting into that, so that would be irrelevant.
All right. What's the state's position on that?
We don't plan on introducing page 304, line 20, page 305, line 11.
Okay. All right. Unless there's any further discussion, we'll move on to page 321, line 24 to 320, page 322, line 6. And that is speculation about where Mr. Williams went after the proposed shooting.
Your Honor, we believe that this comes in pursuant to the court's order regarding co-conspirator hearsay that the court already ruled on. He is discussing what the Deamonte told him about what occurred on the night of the murder. And that already has come in, and the court has ordered that co-conspirator hearsay comes in. And that was back in November of this year. Of last year.
Are you saying, oh, I'm sorry, Mr. Sharp, go right ahead.
Well, so, Your Honor, and the state actually kind of reminded me here, in this transcript, there's discussion about Mr. Copeland picking up Deamonte Garlington and Deamonte Garlington allegedly saying certain things about what happened involving the Donovan Thomas shooting. Now, it is true. November sounds about right, but I did file a motion to declare that hearsay. Your Honor heard my motion. I argued that it was spilling the beans. It's not in furtherance of a conspiracy. You ruled against me. So I feel the need for the record to say, based on that ruling, I'm not specifically objecting to those statements because you've already ruled on them. But
You're still maintaining your objection.
I'm still maintaining my objection. Now, when it comes to this excerpt, the problem is no one, when he says, he gives, what he says are details. He says, and when Thug was at Bentley Spot, they pulled up on Thug, and then they went to Bentley Spot, they wiped the car down, and he said, and he goes on and on about details about what happened allegedly that night. Nowhere did any of the detectives say, well, how do you know this? What's your source of information? Nowhere does he say in this excerpt that Deamonte or Lil D or D told me that. Correct me if I'm wrong, but that's my reading of this. So the state is saying, well, it falls under a hearsay exception. Deamonte Garlington told him that. I don't really see the basis for the state to say that Deamonte Garlington told him that, and that's why I'm objecting, because he's giving information. We know he wasn't there, according to him. He's giving information, but he's not saying where he got it from. And I'm not just going to agree that his source is Deamonte Garlington, and therefore it's a statement by a co-conspirator.
All right,
Your
State.
Honor, I think that would go to weight, not admissibility in the entirety of, and I want to go back to page 320. He multiple times throughout June, this interview, he talks about Deamonte telling him what occurred on the night of the murder. And when we go back to 320, he talks about the fact that Deamonte told him everything that occurred, which would include what happened with the cars after the murder and where they went after the murder, Your Honor. I think that's a question that they can ask Detective Dennis or Gaither, especially Detective Dennis when he comes back again on cross, why they didn't, whatever the assertion is. But the assertion is that everything that Mr. Copeland knew about the murder came from Deamonte, given that Deamonte was with the individuals who committed the murder at the time that the murder occurred, or at various times right before and right after the murder, Your Honor.
All right, any further argument as to pages 321, line 24 to 322, line 6?
Well, I'll I'll just say that, again, the state's saying, oh, Deamonte's clearly the source, and the jury's not gonna, I don't believe the jury's gonna hear this, because Deamonte Garlington has pending charges and he has a Fifth Amendment right, but he was questioned about this. And while he acknowledged being picked up at the McDonald's by Mr. Copeland, he denied saying any of these things to Mr. Copeland. So there's not a lot of corroboration that Deamonte Garlington is the source other than Mr. Copeland's statement itself.
Okay, but I think I've already ruled on this issue, so I understand what you're saying, Mr. Shaw. I'm still gonna admit it over your objection. I'll give you continuing objection on that issue.
Understood.
Okay. Okay, then I think the next series is pages 341 through 350, pages 350, line 17. And then related to that is page 356, lines 9 through 19, and discussion about Officer Robinson.
Your Honor, we had that page 341, line 19, all the way through 356, line, sorry, Ms. Speaker. We had that page 341, line 19 through page 356, line 19 should come out. However, I think defense counsel disagrees. So we would just want to hear what portion they believe should, are they asking to be played?
Mr. Shard, are you asking for the entirety of it because the state's saying they're gonna omit page 341, line 19 through 356, line 19.
If I could just look at.
Sure. Yep.
I'm in agreement, obviously, up till 350.
Line 17 or just
350, line 17.
all right. So that can be omitted. What about the rest of it though?
Well, no, I don't agree.
About what, sir?
I don't agree with the 350 to 356, and the reason is, it's 350 to 356 is Mr. Copeland trying to negotiate himself out of jail and continuing to try to avoid jail, avoid being locked up for the charges that he was just arrested for, continuing to make promises. And I think that that's obviously very relevant for the jury to observe and see what his mind state was at the time, because it corroborates what he was saying on the stand, that he would.
Let me see what the state said. At a minimum, it's fair game for cross. At a minimum, it's fair game for cross. You can cross-examine him on that all day long, from pages 350 to 356. State?
We can play that portion.
All right. State says they're going to play it, okay?
Okay.
So they're going to play pages 350 to 356. You're still welcome to ask him that on cross, okay? So.
And so, as far as time, Your Honor,
Yes, ma'am.
the portions that will be redacted would be from 3:13:55 through 2021.
3 what? I'm sorry, 320?
3/2021.
320, 21.
And that actually ends on page 350, line 3.
Okay, okay.
My suggestion would be to extend that to line 17. Just because Detective Dennis is talking about the dangers of, or the frustration when working with dirty cops. So it's a continuation of the officer.
So Your Honor,
Madam,
that's fine. Up to 350, line 13, I just need to get the exact time that is.
so you're gonna agree it goes to line 17? Just, all right, you get me the
Or
time?
13 is fine. Actually, correct.
Yeah,
Line 13 as opposed to 17?
Yes, sir.
Okay,
so it should be approximately 320, probably 48.
so 3:15:55 to 3:20:48?
313:55.
I'm sorry, 3:13:55.
Yes, to 320:48.
Okay. All right, and then you all will play the pages 350 to 356, which corresponds with what, madam, in terms of audio video?
Time, it'll be 320:49
To,
to about 325:41.
all right,
Except, I still think we need to take out 356 lines 7, 8, 9, something like that to 19, because they go back to talk about the officer.
356, what lines, Mr. Sharp?
9
356, line 9.
to 19. It appears he's being showed a photo lineup of the officer.
Okay, yes, Your Honor, I see
All
what
right.
he's referencing.
Okay.
So we will, out of that, redact from 356, line 9, which starts at 325:10, to line 20, which is roughly about 325:38.
Okay, okay, I think the next portion is 361, page 361, line 1 to 362, line 10. And that's apparently Mr. Stillwell purportedly saying about the shooting on Lil Wayne tour bus.
Mr. Copeland, I may have labeled it wrong. Mr. Copeland, basically, he says, I'm not the problem. If you want the problem is Shannon. They said, why is the problem Shannon? And because this end got so much to prove, it's not me, it's these ends, man. And then he says, Thug, man, whatever thugs say to these ends, Shannon will do it, man. Every time thugs say something, Shannon do it. I say that and beat him up. Shannon shot up that tour bus. Shannon did everything. He shot that gun and killed Nut. Shannon doing everything. It's not me. Y'all keep locking me up. He's already, just to be clear, he's already implicated in this statement Shannon and 3 other men from being in the car. He's already identified, and which I believe will be played to the jury, that Mr. McMullen and Shannon are allegedly gunmen, according to what Mr. Copeland says, who wasn't there. But so this is all extra, all the stuff that would normally be admissible, like he shot that gun and killed Nut. Like if that fulfilled hearsay rules, that would presumably be admissible. All that's already been stated earlier in the interview at this point. This is superfluous. It makes reference to Jeffery Williams just ordering Shannon to do unnamed, untold acts, and Shannon will surely do it. It makes reference again to Shannon shooting up the tour bus, which we know that Mr. Copeland has no firsthand knowledge of. And so I don't see the probative value. It's cumulative based on what's contained earlier in the interview. And obviously there's certain parts of this that need to be redacted on their own right, such as references to the tour bus, such as references to Shannon doing certain unnamed crimes that Kenneth Copeland is broadly referring to.
All right. Ms. Holton?
Your Honor, the state agrees to the portion in which it says, Shannon agrees to the portion, the state, agrees to the portion of Shannon shot up that tour bus. We do believe that that portion can be excluded. However, everything before that talks about Kenneth Copeland, who again, the state will argue is a co-conspirator to the overall gang conspiracy. Speaking of what Shannon's role is in this gang, when he says, man, whatever thugs say, Shannon will do it. Every time Thug says something, Shannon will do it. In this interview, I believe Mr. Copeland talks about, I think it's this interview, that the night that Bloody J gets beat up at Club Crucial on that Monday, that Shannon was a part of beating him up. I believe that's in this interview. I'm going to verify that it's in this interview, Your Honor. So I think that would substantiate what's contained in line 16. And then again, when he says he shot that gun that killed Nut, again, that is based upon what he learned from Deamonte as a co-conspirator hearsay. And so although he said it multiple times, the position that defense counsel has raised is that Mr. Copeland was lying during this interview. The fact that he can remain consistent about certain portions that he speaks to the detectives about, we believe is relevant for this jury to hear. I will play for you his demeanor during this portion of the interview, which I think the jury should be able to view, especially given his in-court testimony stating that he made it all up. Again, the premise is we are playing this as impeachment by contradiction. And when he tells this jury that he made everything up, when you watch his demeanor, especially during this portion, the jurors can determine for themselves if they believe that he is making anything that he said in 2015 up. So for those reasons, we believe everything exclusive of Shannon shot up that tour bus should be admitted. We do agree, and we will omit the portion Shannon shot up
Line
that tour bus.
16. Okay, all right. You can play it. Please.
And Your Honor, it'll begin around we'll start at 3:29:27.
know Shannon do it. Are you blaming you? I said, that nigga told us, they go blame you like that shit, that little deal on people. Shannon saw that too, but Shannon did everything. He shot that gun, killed her. Shannon doing everything. It's not me. That's what locking me up. Cause Shannon working, man.
And there are exclude the parts that Shannon shot up that tour bus, but everything else we believe will come in. And as I did mention earlier, around 10:41 in this interview, so earlier in the morning, he spoke to the detectives about that Monday night at Crucial and being outside of Crucial, Thug saying, there go Bloody J, there go Bloody J. And then Shannon went and proceeded to beat up Bloody J along with Moontalk. And that was that night preceding Donovan Thomas's death.
All right. Mr. Steele, did you have?
Yes. Judge, I'd like you to consider the state's premise is OCGA section 24-6-621, which is what they're calling impeachment by contradiction. And impeachment by contradiction, or 24-6-621 rather, states, and I quote, witness may be impeached by disproving the fact.
Hang tight, Mr. Steele. Somebody's got to. You see. Well, correct. All right. Sorry about that. Start over.
OCGA, the state's premise is that they are using these recordings, 16 hours of recordings, because Mr. Copeland said, I probably said it, but I was lying. And the state is saying that this is falling under OCGA section 24-6-621, which is impeachment by contradiction, specifically stating, and the legislature wrote, a witness may be impeached by disproving the facts testified to by the witness. And Mr. Copeland never testified to any of it. The state is really doing, well, we want the jurors to see it so they could rate his credibility because he was telling the truth. That's an inconsistency. But he's really not inconsistent because he really said, I probably did say it. But by the way, I was lying back in 2015. As the Honorable Bruce Harvey was saying, a prior consistent statement is not usable under 24-6-613 because the motive was already there because he's constantly saying, he being sorry, Mr. Copeland, I want a deal. That's his motivation for speaking with the police. So it's not recent fabrication. So I just bring this to your attention because I don't want any of this to be played, and the state keeps just using this brush that I think is painting the wrong object. Also, prosecutors said that the defense claims that Mr. Copeland lied in these statements. I haven't claimed anything.
I understand that because you haven't crossed the witness yet.
This is Mr. Copeland's testimony saying he lied. In fact, there's parts of the defense don't want to cross-examine potentially Mr. Copeland because what are you going to get? He already admitted all this. So to me, Your Honor, I would just ask you to reconstruct. I just don't see how any of this is coming in unless the state lays a proper foundation, which they have not.
One thing that, to my recollection, this part of Mr. Copeland's testimony or his statement that we're sort of focused on about, especially with the Donovan Thomas killing, about who was in the car and all that, I don't believe that that's ever even been inquired to on direct at this point. So I don't even know whether we're talking about prior inconsistent statements, whether we're talking about impeachment by contradiction.
Well, that's what the state's saying. They're
Right,
saying it's impeachment by contradiction.
but Mr. Copeland, I don't believe a question's ever been posed to him about whether he was told what he was told by Mr. Garlington at this point, whether he was told that Mr. Stillwell was in a car, wasn't in a car, whether he was told that Mr. Kendrick was in a car, wasn't in a car. I don't believe that we've ever touched that on direct. So I don't know how playing statements, out of court statements regarding these matters shows any sort of contradiction, because there's nothing's been said.
I think they're also trying to offer them for co-conspirator statements. So you want to address that?
Yes, Your Honor. So multiple things. I believe, and again, I would have to go back to the record, that early in my questioning with Mr. Copeland, I asked him about the murder, and that is when he—
The murder of whom?
Donovan Thomas, or the night of, and I believe his testimony in court was that Little D got in a car and Little D didn't say anything. And I would need to go back and look at that portion, but I believe that is what he testified to in court last week. Then furthermore, he testified in court that Shannon got into the car with him and not Nard, who he said back in 2015 got into the car with him. So as it relates to what Deamonte told him, that would be impeachment by a prior inconsistent statement, given what he said in court versus what he said back in 2015. But again, Your Honor, this is impeachment by contradiction, and the foundation is there is because in court, Mr. Copeland has consistently said, I made it all up just so I would tell them anything, just so that I could because I wanted to get out of jail. I did not want to go to jail, so I made it all up. Anything they wanted to hear is what I told them. So again, that is the foundation as to why we get to play this statement, because he's telling this jury everything I've ever said before was a total, maybe he didn't say the word lie, but he said I made it all up so that I could just get out of jail. And I was telling them anything that they wanted to hear. They were pressuring me about Thug, so I told them about Thug. And again, this is in complete contradiction to what actually occurred in that interview room. So we believe the foundation has been laid overall by impeachment by contradiction, but specifically to address whether or not we asked Mr. Copeland about the night of the murder. I want to make sure the record's clear, but I believe I asked him a line of questioning regarding the night of the murder. He said that Little D got into the car but didn't say anything, and that he also changed who was in the car with him. He said that Shannon got into the car and that Nard no longer got in the car, but that is what he told officers back in 2015.
All right, I'm going to defer on that till you get me the last little piece of it. So we'll come back to that particular page 361, line 1 through 362, line 10. We'll go ahead and come back to that.
And Your Honor, is the deferment regarding whether or not I asked in that line of questioning?
Yes.
Okay.
Because it will make a difference as to whether or not, from what Mr. Steele and Mr. Shard are saying, but you are going to admit Shannon shot up the tour bus on line 16. So,
We will admit that.
okay, all right. Like I said, we'll come back to that one. Let's go on to 375. I'm sorry, 365. Page 365, line 6 through 365, line 8.
This is another hearsay statement about, according to Kenneth Copeland, Mr. Williams wanted to buy that gun. And
Thug told him being who? Allegedly.
told him, I
Who
think
is
what
him?
he's referring to is he told Quamarvious.
Quindarius Zachary? Okay.
But we've already argued about this issue. Kenneth Copeland's basis of knowledge about what Mr. Williams may or may not have had planned with that gun was based on hearsay. So, we dealt with that.
So I ruled on that already.
Yes.
So it's out.
We just have a continuing objection. to
You
that.
can, yes, you certainly may. Okay, let's turn our attention now to page 375, line 17 through 376, line 9. And I want to say, I think that is 404B issues in regards to, I think, Mr. Williams is connected to a lot of people. Also, Thorpe talks about the defendants being convicted.
Right.
Your Honor, the state will redact page time frame 33910
339:10,
through 33939.
339:39.
But we would object to 33904 through 33910. So the beginning of it, we object to.
Ms. Hill, can you just tell me the, transcript?
Sure, hold on. So the state believes that from page 375, line 16, through line 19 should be played. From 375, line 20 through 376, line 9, we don't object to being redacted.
Okay. Let me read it. So you want lines 16 through 19 played? Is that what you're saying on 375? Ms. Hilton?
Yes, Your Honor.
Okay, all right. Mr. Sharp?
Your Honor, I believe that those lines that they want to play invite speculation as to threats and different concerns about witness safety. And again, in this case, despite what's been said in court at times, there's never been any evidence or any reputable suggestion that Mr. Williams or any of these other gentlemen have intimidated witnesses in this case. So I think that that's an improper comment on Mr. Williams' character and through proxy, my client, Mr. Stillwell's character as well.
Your Honor, I do think that we have to read this in context. So really, you can't read that statement outside of looking at line number 7, and I can play the whole portion. But starting at line 5, again, this is this
On page 375?
on page 375, they're talking about snitching, essentially. And what Detective Gaither asked him is, even if you know who did it, who actually fucking did it, and we can prove it. And he says, okay, now listen to this. Either way it go. If I was to tell y'all, okay, they're gonna kill Nut. Now they get locked up. They find out that I'm the one who told. And they can show it in black and white. Okay, but that's what I'm saying. On the street, it'll be y'all, that nigga Thug connected to a lot of people, man. And that's where he ends at. So this whole portion is in direct result of him talking about snitching and coming forward to testify and coming forward about what happened to Nut. And that is relevant for the jury to understand or determine for themselves why he's changing his testimony here in court today or here in court in 2024. But I can play the portion so that the court can hear him.
Sure.
And we'll start it at 3:38:34. Oh, sorry, Your Honor. I never realized the screen wasn't showing.
Why get that off your own, man? Come on, man. Anybody know who did it, who actually fucking did it, we can prove it. Hey, now listen to them. He wiggled. Now, okay, I want to tell you, okay, say who killed that. Boom. Okay. Now, they get locked up, they find out I was told. And they can show it in black and white. Okay, but they gonna do that. Where's the thing? On the street, yeah, they get thrown connected to a lot of people, man. And listen, this was.
And then stop playing at 3:39:09.
All right. Anything further, Mr. Short or Mr. Steele, in regards to the three lines, 375, 16 to 19?
No, Your Honor.
All right, I'm going to admit them over your objection. I'll give you a continued objection on that. They give context to the earlier lines that are played. Okay. Let's turn to page 378, line 1 to 378, line 8. And them four ain't gonna tell, comment on silence. Is the state gonna play that 378, line 1 to 378, line 8?
Yes, Your Honor. And we don't believe that's a comment on the defendant's silence.
Let me hear it, please. And tell me what audio visual marks are those as well too, please.
It'll be 3:40:38.
3:40:38.
Yes, through 3:40:56.
All right.
And we're starting a little earlier at 3:40:31.
But the thing was, I can
getting mad now?
It ain't, no, y'all ain't, you ain't, I still think it's anyway. Those of them already knew it. Like, them before right there, they not gonna tell you. I don't know about too much, but them niggas not gonna tell you, somebody they not saying. You know what I'm saying? I understand man around enjoying this stuff, but a nigga gonna make a way. They be like, what he told them. You know what I'm saying? Okay, and once again.
And we stopped at 3:40:58.
Right. What's the state's purpose for playing that? Or what's the admissible, why do you think it's admissible, Ms. Oden?
Your Honor, so first, if we go back to the beginning, again, reading it in context, this conversation comes about after, again, this is on the heels of talking about the fact that even though he's telling the detectives what happened, he's still concerned about being labeled a snitch. And what he says preceding this, Your Honor, Detective Thorpe so after the portion we just heard, Your Honor, in the part that defense counsel has asked and the state agreed to take out, Detective Thorpe is telling Mr. Copeland that they're not going to be worried, they being the individuals who did this crime, once they find out that it was you who told, they're not going to be worried about you. And they go into a conversation saying that they are going to, Mr. Copeland said they are going to worry about the fact that I told. And they continue this conversation back and forth regarding talking about what happened. And they're telling him that you waited too long. Mr. Copeland's concerned that people on the street believe it was him that did the murder. And they're telling him, you should have told us months ago that you were not involved. And then he continues to talk about why people are going to say it was him who told. And so this all goes back to his concern about the fact that people are going to know that he told the police about what happened. And I think it'll be better in context to play from 3:39:39 up until 3:40:38, so you can understand fully the context in which this statement comes in, because it can't be looked at in isolation.
You said 3:40 what?
3:39:39.
3:39.
Yes, all the way up until 3:40:38, because all of this in relation to the portion that the court just heard.
So you're gonna do 3:39 to what? 3:40 to what?
3:40:38.
All right, you can go ahead and play it.
Yes.
And shit gonna be proven that they killed them. They gonna be housed up. They gonna have to worry about how to get back in too, because most of them gonna be in there trying to get carried out. Because they gonna say, oh, y'all put the blame on my man right here, and then only to your own shit. Y'all let y'all dog right out there by himself without getting him no motherfucking cover, no fucking blanket. They gonna be worried about motherfuckers coming downstairs. They gonna be too worried about themselves and worried about where you at. You gonna tell you what how it going now? It go like this now. Mm-hmm. They worry about their lady. What they gonna be worried about You see how many people worry about me now with these murders? You see, everybody worry about this and these murders. People still call my pictures. Why you just walk around and say you know you don't kill nothing? Come on, man. Because you haven't told anybody else this. You haven't started with, this is the mouth of the street right here. When people watch it, hit the news, this man had nothing to do with it. 11 police locked up these 4 motherfuckers for his mother. Then they're like, oh shit, man, what are you doing? You understand it? So what? Nah, I ain't with them. My brothers. That's what they gonna say. Okay, but they ain't gonna do. There's no way to go. You should have killed that story when the shit happened. You let that fester. We can't change what the street already know. You been wrong with it for 6 months. How can you get mad now? It ain't. But y'all ain't. Anyway. Those of them already knew. Like, them before right there, they not gonna tell you. I don't know about Tupac, but them niggas not gonna tell you. That's why they not saying. You know what I'm saying? I understand everybody enjoying this stuff, but I think gonna make it way. They be like, what he told you. You know what I'm saying? Okay, and once again, this is what you gotta worry about. That's you. That's everybody that you gotta worry about. Which one? Exactly. So why are you still telling me what they're gonna say when they get their discovery back to what I was doing? Just fuck them. These are the 2 people you need to be worried about, like this.
So again, Your Honor, listening to that whole portion in context, they are talking to him about his concern about what's going to happen when the paperwork comes and when what's going to be in black and white. And so again, you have to read this portion in context with what they were talking about before and what in this portion of the transcript, Your Honor. So we believe again it is all relevant. Again, with Mr. Copeland's concern about telling the police what happened regarding the murder of Donovan Thomas Jr. And the fact that it's not a comment on anyone's silence. I'll cite the court to United States v. Reeves, which is a 2014 11th Circuit case, 742 Federal 3rd, 487. And it cites Doyle v. So first and foremost, no one's pre-arrest silence has been commented on, period, because no one has been arrested at the time of this interaction with Mr. Copeland. But furthermore, in the United States v. Reeves case, they cite to Doyle v. Ohio, which is a United States Supreme Court case. And it says the Supreme Court held that the use of a defendant's silence at the time of his arrest for impeachment purposes violates due process because warnings pursuant to Miranda v. Arizona carry an implicit assurance that silence will carry no penalty. The court later extended protection to post-Miranda invocations. The error is especially harmless when the prosecutor makes no further attempt to highlight the defendant's exercise of his Miranda rights, either in questioning other witnesses or during closing argument. The government may comment on a defendant's silence if it occurred before the defendant was in custody and given Miranda warnings. So again, here, no one's even in custody. No one has been given Miranda warnings. And so the fact that Copeland is talking about the fact of who may or may not come forward is not an improper comment on the defendant's silence.
All right. Ms. Sharp.
The state, the cases I heard it read, found harmless error. So I would like to avoid error, whether it's harmless or not. So I don't think we should be relying on that case. But also regarding pre-arrest silence, I don't, that comment was not about pre-arrest silence. That was a perspective comment about what would happen when these gentlemen are brought in. I see no probative value. I see no benefit to playing that portion of the tape. I do see harm. I don't believe that pre-arrest silence is a settled area of law right now in Georgia. But again, I believe that this, while the comment was made prior to arrest, that is true. It was a comment about once these gentlemen are arrested, they will not say anything. And that would be improper.
Your Honor, again, this is Mr. Copeland saying this, not any of the law enforcement officers. And this again goes to show why Mr. Copeland delayed in even telling the police about what happened on the night of the murder. Because he had been talking to the police, he thought that they would know it was him. And so again, this goes to Copeland's mindset as to why he waited until June to come forward. And again, why he told the police what he knew about the murder.
Right. In considering the lines from 378 line 1 to about 378 line 8, corresponding times 3900 to 3438, the court's going to permit that to be played over a defense objection. I'll give a continuing objection.
Mr. Glanville, can I just add one thing?
Sure.
To that analysis?
Yes.
If you would allow me.
Yes, go ahead.
I meant to do, I didn't want to disturb.
No, no, go ahead. Go ahead.
I meant to do before you rule. So we discussed before state versus ORR, which is 305 Georgia 729. It's Division 3, 2019. That's 305 Georgia 729, Division 3, 2019.
305 Georgia, what? I'm sorry, one more time.
305 Georgia 729, Division 3, 2019. And that's where the Georgia Supreme Court said that Georgia no longer has a per se rule not to comment on someone's silence pre-arrest. So when you have to do those, your 403 analysis. And what I'd like you to take in consideration, if you don't mind, is its supposition. This is
Okay,
what
but
Mr. Short was saying.
I was going to ask you to, there's also a couple of the cases. Are you familiar with Jackson versus State, 317 Georgia, 139 is decided August the 21st, 2013, talks about pre-arrest and post-arrest statements.
I'm confident I'm familiar with it if I looked at it.
Okay, all right. So,
But I have two things to say about it without, and I have to pull it up. But if it's 2013, it would be an appeal from a trial that happened before January 1, 2013. And the court until 2019 said we were following the Mallory, which is MALLORY rule, which excluded pre-arrest silence in Georgia.
I seem to remember that.
What the state cited to you in Doyle, DOYLE versus Ohio, that is post-arrest silence. That never can be discussed. And what the state said about this is Mr. Copeland, not an arm of the prosecution, who put in the pre-arrest silence. That doesn't matter because it's the accused rights. And that's it's a comment upon the defendant's silence by a witness, which is impermissible under our law. That comes from.
Go ahead, I'm sorry.
That comes from Jackson, JCKSON versus State 336 Georgia Appeal 70. It's Division 3, 2016. But my point is that the state, in my estimation, strikes out all three times because one, it is a comment on silence because he being Mr. Copeland, directly saying these individuals will not say anything. That's guesswork because you can't predict the future. And it does not have to be a law enforcement officer. The state can't ask a layperson to comment on someone's silence, whether it's pre or post. So those are my objectives. I understand your rule.
No. I appreciate you bringing up the issue of the timing. For that reason, I'm going to reverse myself. I'm going to admit it.
Can I, before you do that, Your Honor, in reading or actually abrogates Mallory. And so when you read or, Your Honor.
Remember, I've gone through this before about or.
So, and again,
Wow.
Your Honor, when you're talking about pre-arrest, comments on pre-arrest silence, that's saying the defendant, when he did not, even after giving Miranda.
But you got to look at when the statement was made. The statement was made in 2005?
No, Your Honor. So the or case that Mr. Steele cited abrogates the Mallory rule. So it's saying that the rule of Mallory is no longer in effect. So no, Your Honor. Respectfully, that is inciting or that is confusing the issue of what happened in Mallory. What the court says, there's no blanket exclusionary rule. That rule in Mallory is no longer in effect. So it says the analysis now requires careful consideration of a specific sorts of evidence that come with the broad phrase silence or failure to come forward may be properly offered under which particular evidence, rules, and theories. In the decades since Mallory, lawyers and judges in our state courts, including this court, have rarely had to grapple with these questions because whether or not such evidence might be properly admitted under any particular theory was irrelevant. Mallory's rule meant that the evidence will all be excluded in any event, but that's not the case anymore. Moreover, the grappling now occurs under the new evidence code, making reliance on pre-Mallory Georgia precedent generally inappropriate. So again, what Mr. Copeland did is not comment on anyone's pre-arrest silence. He said, the reason why I am concerned is because none of these other people are going to talk. So they're going to know it's me. That is an appropriate assessment of Mr. Copeland. This is not the state commenting on the failure of any one person's coming forward. What Mr. Copeland is saying is they're going to know it's me because none of them going to come forward. That is very different from commenting on the fact that the defendants did not come forward.
Okay, so or
And it's-
applies because Mallory hadn't been decided. In that case, majority held that this court had not yet overruled Mallory. It was bound to apply it.
Correct. So Mallory was the old law.
All right.
But
And the new law, what Orr says is forget Mallory. Mallory doesn't exist anymore. For the new evidence code, that bright line test no longer exists. Now you have to look at it on a case-by-case basis.
Yeah, it says right here, the court then announced Mallory's categorical exclusion rule in the following passage, and they quoted, "In or we take this opportunity to hold in criminal cases a comment upon the defendant's silence or failure to come forward is far more prejudicial than probative. Accordingly, from the date of the publication of this opinion, December 26, 1991, in advance sheets of Georgia court, such a comment will not be allowed even when the defendant has not received Miranda warnings and where he takes stand in his own defense. To that extent, holding in Fraley versus State 256 Georgia 178 conflicts with holding is overruled." So, and it talks about Mallory, goes into big discussion about that. But in any event, having identified the provenance of Mallory's rule, there's no doubt it was abrogated by the new evidence code. So.
Your Honor, the state disagreed with Mr. Steele, but then agreed, they said they disagreed with Mr. Steele, but then they agreed with everything he said. Or did
In terms
abrogate.
of what?
Well, it's, or did say there's no bright line rule, and that's why I said in the beginning when I was speaking that the law with pre-arrest silence is a little bit unsettled. But what it really comes down to, as Mr. Steele said, was a 403 balancing.
Well,
None of us are claiming that the bright line Mallory rule is still in effect. But the state seems to be implying that pre-arrest silence, there's like no protections, and that's not true either under or. It's improper to comment on the pre-arrest silence to the extent that it prejudices the defendants. There's scant probative value here, if any at all. And the fact that Mr. Copeland or anyone else is commenting about what my client's likely to do with being arrested. First of all, it's speculation. But secondly, it's an improper comment on his right to exercise his constitutional rights and remain silent. As it is for Mr. Kendrick.
Your Honor, I believe that when the courts are talking about commenting on a pre-arrest silence, it is the government commenting on the fact that an individual, after when he was Mirandized, decided not to talk, or that he was the suspect and decided not to talk. And the state is commenting saying, if he was innocent, he would have come forward. That is not what is happening here, Your Honor. What is happening is Mr. Copeland, in talking about why he does not want to be in the paperwork, or how are people going to find out that he was the one who told, is saying they're going to know it's me because these other people, they're not going to talk to y'all. They're going to know it's me because I have been talking to you all. And so they're going to know that I'm the one who gave up all the information about the murder. So it is very distinguishable from what Mr. Shar is arguing. And there's no case that will say that a witness saying, I am concerned that they're going to know that it is me who disclosed this information about the murder, is commenting on pre-arrest or post-arrest silence. Because it is generally the context of the state arguing, if this person was innocent, they would have done this.
So you're not, yeah, you said that already. So you're saying that or applies when you got a defendant.
Yes.
Okay, not a witness necessarily. All right.
And so I didn't mean to say yes so abruptly. Sorry.
It's okay. All right. All right, Mr. Steele, unfortunately, I'm gonna go back to my original ruling. So I'll note your objection and that you cited or once again, and I will give you a continuing objection on that issue. All right. Okay. Okay, we have 381, line 1 to 381, line 8. And I want to say that applies to, there's some unsupported and speculatory comments about what Mr. Stillwell is apparently thinking by the police.
It's commentary by Detective Dennis. It's speaking to Kenneth Copeland. Now, mind you, we're playing these based on contradicting Kenneth Copeland's words. So Investigator Dennis's words, unless they're adding some sort of context, would seem irrelevant and inappropriate to play as a general proposition. Detective Dennis in this case says, Shannon, to Kenneth, says, Shannon seen an opportunity in you, and he took. He said, oh, Woody can't really be the go-to. He ain't ready to be LeBron. He want to be whoever else. I'm ready to be LeBron. So since he ain't going to step up to the plate and take it, I'm going to take it. And if that means sacrificing my childhood friend or whatever y'all are, then so be it. So that's all the detective.
Your Honor, the state has no objection to that portion.
All right, so you're gonna omit that?
Yes.
Okay, all right. So tell me the transcript, not transcript, but the audio visual.
Yes, Your Honor, it's going to be 342:51
342:51.
through 343:08.
Okay. All right.
Your Honor, can we take a comfort break?
All right. Take 5 minutes. Okay,
For
folks,
even
here's what I'm trying to get through. Okay, we have about 10 more references to go. I'd like to finish those. Mr. Steele, Mr. Adams, I don't believe I'll get to yours until the ones you all have until tomorrow. And since we're working kind of an abbreviated day tomorrow, and then we'll work on Wednesday. That'll be the order of business for the next couple of days. So that's what the court's attempting to do is you've got about 10 more references to get through from Mr. Shart's, well, there's 3 more from Mr. Shart, and then I'm sorry.
Mr. Sharp has stopped at 398.
Yeah. Then there's some ones from the state that we have.
Chronologically, those kind of, then they start to bleed over into, hours. And we pick up at about page 400. And so the ones that I submitted earlier, which I believe starts at page 413, actually would come before a lot of what you're looking at here. So just in terms of keeping it neat, Mr. Sharp ends at 398, and then we pick up at 413 after that. It would respectfully, it would probably, excuse me, I'm sorry.
That's right. You're fine. You're fine.
I'm speaking on this, Weaver. Respectfully, it would probably make more sense for us to kind of launch into our portion of it whenever you want to, whether it's this evening or tomorrow, just tomorrow.
Easiest decision I'm gonna make, right, Mr. Adams? Okay, all right.
Easy one.
All right, yes. Okay,
So
All right.
I'll suggest we stop at 398.
all right, let's do that. Okay, so we'll go ahead and we'll take 5 minutes. So as soon as we can finish, exhaust those last couple, and then I'll talk generally about what our goal for the next couple of days into the first week of July will look like, okay?
Yes, thank you.
All right, so we're in recess for about 5 minutes. All right. Do we have all our participants? Okay, okay, there's Mr. Shaw. Okay, I see him up here. All right. Okay, all right. Check your neighbors. Okay, all right, good. Okay, couple more to go. So 387, page 387, line 6 to 13. Hearsay about what Nutt said to Mr. Copeland.
Right. So in this portion, Mr. Copeland is it's pertaining to the issue that Mr. Copeland, the reoccurring issue he has with Kelvin Watts, and it's Mr. Copeland tells the police a rendition of what Donovan Thomas supposedly told him about that feud and about Mr. Thomas's willingness and desire to make peace between Mr. Watts and Mr. Copeland. So
this is what Nutt apparently said to Copeland?
yes,
Okay.
and so that's hearsay in our estimation, and we would ask that be redacted.
All right. State?
I will play the portion. We're not offering it for the truth of the matter asserted, but to show the effect on Mr. Copeland in his state of mind as it relates to the relationship he had with Nutt prior to his death. But I'll play the portion and it'll start on 386, line 15, which at 346:42, and I'll play through 387, really line 18 for the full context of the statement. And we're gonna start at 346:37.
Hey, I wanted to I know you don't want to hear me. I was like, damn, bro, what is him? I don't think I did. I didn't have that shit. That nigga ain't the problem. Know what I mean? The nigga Cal is. That was the stuff I feel like. And then I can remember like the stuff Nut used to be saying. I mean, like Nut put up at the Gavin house and he tried to talk to me. You feel me? I did one night. I cracked one. He like, damn, blood. I ain't blood, bro. Know what I mean? But damn. Know what I mean? So I pulled over. When I pulled over, I got caught and they did boo talking. I mean, I jabbed him up. Boom. Shannon right there. Shannon walked right there. Looked at him like, you know what I mean? Mm-hmm. And he was like, man, what's up with you and Kel? Like, man, they him tripping, but I ain't got no problem with it. You know what I mean? So we were talking, we got there and talking. So I remember how that nigga, I'm gonna let y'all niggas know what's up, you know what I mean? This and that. That's what Nut said, yeah. So when me and Kel seen each other came, Kel was like, well, he gonna see what Thug got to say. So I called Thug on FaceTime for Kel. And Kel like, nigga, ain't that shit, go till you pay for my window.
And we stopped at 3:47:45, Your Honor. And so when you listen to the context, one, the two portions that I believe the defense is saying is hearsay is when Mr. Thomas said, first, he like damn blood, because that would be, and that's on page 386, 283. And you need that in context to know what Mr. Copeland's response was, which was, I ain't blood, bruh. And then the next hearsay statement that I guess defense is purporting as hearsay is when Mr. Copeland says, man, what's up with you and Kel? Which is a question. That's not a statement, it's a question. And Mr. Copeland's response is, man, these niggas let him trip with y'all. I ain't got no problems with him. You know what I mean? So we were talking, when we got finished talking, he was like, I guess this is the third statement that defense counsel is saying, it's hearsay. Man, I'ma holler at the nigga. I'ma let y'all niggas know what's up. You know what I mean? This and that. And so that statement, we're not offering it for the truth of the matter asserted about whether or not he went and hollered at, I'm assuming the nigga is supposed to be Kel. We're not offering it for the truth of the matter, whether or not he went to go speak with Kel or not, but for the context in which Mr. Copeland is telling the detective about his interaction with Nuts. And then furthermore, when he goes into what happens at the skating ring, him meeting up with meeting Kel at the skating ring and them talking about the issues that they have, which we've already talked about on multiple occasions. And so I think this gives context to events that led up to him meeting with Kel at the skating ring, we believe the Sunday before Donovan Thomas passed away. But we're not offering any of these statements for the truth of the matter asserted.
All right. Sharp. Sorry.
I'm not sure why Kenneth Copeland's state of mind is an issue here. Mr. Copeland can easily testify, preferably live to the extent he hasn't already, about meeting with Kelvin Watts and the conversation he had with Kelvin Watts in person. He was there. This recording also discusses that conversation he had with Kelvin Watts and what was said. But I don't know why hearsay of Donovan Thomas through Kenneth Copeland is needed to understand or provide context to Mr. Copeland's conversation with Kelvin Watts. It's perfectly understandable without that context. Mr. Copeland met with Mr. Watts. They discussed matters, and Mr. Copeland can explain it to the jurors on the stand, and I anticipate he would say that we agreed to try to come to an understanding, and then phone calls were made to Mr. Williams. But things that Donovan Thomas said are not needed to understand that discussion between Copeland and Watts.
Anybody else wish to be heard on that issue? Yes, Mr. Steele.
I join in entirety what Attorney Max well, Shard said, but I'm trying to understand, if it's not for the truth of the matter asserted, how does it even get through 401 or 402? Because if it's really not for the truth of the matter asserted, and it just gets to how a meeting occurred later, if it's not that, hey, Donovan Thomas said this and it's truthful, and that's what initiated the meeting, then it doesn't matter. The meeting happened. And in fact, on direct examination, while we had a jury here, Mr. Copeland was specifically asked about this, and the state impeached him and said that you did have FaceTime call with Jeffery Williams in front of Mr. Watts, who's been referred to as Cal. So that's my only addition. But otherwise, I don't know. I really don't know why this is being played for the jury. And I'll add 403 analysis as well, because it seems very confusing. We're playing, we're going to have more testimony from a recording than he's really testified live. And at some point, I just think it breaks. And the state and I'm not saying that it's accurate, but they said as already proven, meaning that this is cumulative. Now, that may be just a part, because I wasn't sure, I wasn't following what they said has already been shown. But whatever they said was shown or testified to already, then this would be cumulative. So for all those reasons, sir, I asked for the court to, I'm just usually trying case with a witness and not with these videos.
And Your Honor, I can respond directly to the 401 and 402 assertion.
Sure, go ahead.
Your Honor, as it relates to relevance, in this matter, Mr. Copeland in this interview discussed that he had no problems with Nut, that he had no issues with Nut, and this is further corroboration of that assertion that he had no issues with Nut. Matter of fact, he talked to Nut about the issues that he was having with Kel. And in our testimony, we talked about the fact that Mr. Thomas was trying to diffuse any beef with Kel and Copeland prior to his death.
But hasn't Mr. Copeland already testified about the items on page 387? I don't know if he's testified about about the damn blood. I ain't no blood, bro. I don't know if he testified about that, but what about the stuff on page 387?
And I would have to go back to my questioning of him. I think, and again, I would need to go back to the record. I may have asked him some questions along the lines of him having conversations with Nut, and he may have told me he'd never had any conversations with Nut. But again, I would need to go back to confirming that, like in court, I may have asked him, does he recall having any conversations with Nut? And I believe he may have testified that he's never had any conversations with Nut. So
I don't know, because I think he's testified about from like on page 387, lines 6 through 12. I think he's testified about that on direct already. So you might want to check that.
I would.
You need to
we
check
can
that.
hold this until
I'll hold it, but
confirm.
I mean, I don't know. I don't think he's testified about the info on 386 in terms of the, but I don't know if he testified about that. Not pulling up to, this is page 386, line 21. So you might want to check that as well.
Yes, and we can hold on that, Your Honor.
Okay, we'll hold it. All right. The next section is page 389, lines 1 through 17. And that's hearsay and confrontation clause statements of Nard and Jeffrey's sister.
So, Your Honor, I believe that when I say Jeffrey's sister, I'm referring to Dolly, also known as Max. And there's statements made by Mr. Copeland in this transcript where he says he says he's never heard anything from Shannon talking about anything involving this. But he does say he's heard Nard, who I believe to be Demise McMullen, talk and laugh about it, saying, man, F that B, ITCH. And then he says he's heard Dolly say, F that N, allegedly in reference to Donovan Thomas. Now, neither of those statements are confessions. Neither of those statements are admissions. Those are just statements about their thoughts about that individual, Donovan Thomas. So they're not admissions by a party opponent. Neither of the two individuals are party opponents to begin with, but they're not admissions by a party opponent or anything like that. They're just apparently statements that Nard has said F him, and Dolly White, or Dolly, known as Dolly White, has said F him, meaning Donovan Thomas as well. So I don't see the relevance. None of them are sitting here at this table. My client has said nothing of the sort. None of these other gentlemen have said anything of the sort. So it's irrelevant. It fails 401 and 403.
Okay.
And also hearsay and the confrontation clause.
Ms. Hilton? Are you gonna seek to play it?
Yes, Your Honor. You want to play it first? Or?
Not necessarily. I read it. It's got a lot of purportedly vulgar language for this time of night. So, but I've got the transcript, and
So, Your Honor, we
Right.
believe that it is relevant, and it's also what we deem to be co-conspirator hearsay. So, Your Honor, first things first, as it relates to relevancy, Your Honor, what we have is Mr. Copeland telling the police what he learned from Deamonte regarding the murder of Donovan Thomas and what happened. And to further kind of corroborate what he told the police, he's asked that you have to go back to page 388. He tells the police, so they be talking about it. You know what I mean? He says, but I ain't never heard Shannon talk about it. I never heard, but I heard Nard talk and laugh about it. You know what I mean? So first things first, Nard is one of the individuals who he says was in the car at the time of the murder. Matter of fact, he's one of the shooters, according to what Kenneth Copeland tells the detectives. And he's saying that he's heard Nard talk and laugh about it being the murder of Donovan Thomas. And Nard has said, man, fuck that bitch.
referring to Mr. Thomas, the decedent.
Yes, referring to Mr. Thomas, the decedent.
Okay.
So again, that would.
Then he says, I hear.
Thug's sister
This
talking
is on
about.
page 389, lines 1 through about 6 for
It's-
reference.
Yes, Your Honor. He said she was talking about it a lot. And Your Honor, earlier in this interview, he talks about the fact that Shannon has told him that if you want to know anything about what's going on, his sisters know about it. We believe that Miss White, or I think her real name is Alexis Greer, is an unindicted co-conspirator, Your Honor. Here in this case, in the unindicted co-conspirator of the larger gang conspiracy. We have already submitted evidence before this jury of a video containing Miss Alexis Greer back in about 2012, 2013, where she's in a video with her brother. Your Honor, if you can recall, this is the video in which Mr. Williams comes out of the home. He's kind of pointing a gun at the camera. He's talking about YSL. And in that video later on, a young lady is also pointing a gun at the camera. talking about YSL, that we believe is the same sister that we're talking about here. Your Honor, we've also heard evidence of Alexis Greer's phone being in the area of the bus shooting when the bus shooting occurs, Your Honor. So we believe that Ms. Alexis Greer is an unindicted co-conspirator to a larger gang conspiracy. So when Mr. Copeland is saying that I've heard her talk about it a lot, and then when you go down to line 14 and they ask him, what does she say? She says, yeah, fuck that nigga, something, something, something. That nigga better not play with my brother. You know what I mean? And again, this is all referencing Mr. Donovan Thomas. And so we believe that this is a co-conspirator statement that is in furtherance of the larger gang conspiracy, Your Honor, that is afoot with YSL. We will cite the court to Kemp v. State, which is 303 Georgia, 385.
303 Georgia, what?
385.
303 Georgia, 385?
Yes, Your Honor, which is a 2018 case.
I think you may have said that before. Where's Kemp?
Yes, Your Honor, we cited Kemp in our brief regarding the co-conspirator hearsay statements regarding Mr. With the statements that all of the co-conspirator statements, but specifically when we've asked the court to rule on Meghann Cuniff's statement to Kenneth Copeland.
All right, madam, anything else?
And I can go in. The court explained that a criminal street gang is a general conspiracy and among individuals to commit the crime. Therefore, although the murder in Kemp had already been committed when the speaker in that case provided information about the crime to his co-conspirators, a fellow gang associate, the larger general conspiracy, and the germane one, the Gangster Disciples criminal street gang, was still an ongoing criminal conspiracy. The court explained the fact that the defendants accomplished the specific acts charged. The charged murder did not end their involvement or association with the Gangster Disciples, nor did the criminal street gang purpose necessarily end those crimes. Further inciting Chavers v. State, which is 304 Georgia 887. Your Honor, we believe that this commenting of what both Nard and Dolly says is in furtherance of the criminal conspiracy. And I'm trying a specific language. That this comment is in furtherance of the conspiracy. And I'm sorry, going back to Kemp, they apply a liberal standard to determine whether a statement is made in furtherance of the conspiracy, and statements that further the interest of the conspiracy in some way meet this standard. And we believe that this commenting on Mr. Thomas Jr. after his death furthers that conspiracy, furthers the cohesiveness of this gang, and we believe that it should be entered under a co-conspirator hearsay.
All right. All right, Mr. Sharp.
I'm aware of the Kemp case. It's a bit of an outlier case, taking a broader view of co-conspirator statements, but even the Kemp case under these facts, under its reasoning, would not label these statements. Essentially, F. Donovan Thomas is essentially what they're saying, F. Donovan Thomas. How that is in furtherance of a conspiracy is beyond me. If that's in furtherance of conspiracy, then the requirement under the rules of evidence really has no meaning. If two co-conspirators say, we need to meet tomorrow at high noon to count the money, I get it. Retrospectively saying F. Donovan Thomas does not further the conspiracy in any way. I'm sure your Honor is aware, State v. Wilkins, 302 Georgia 156. That's a 2017 case. State v. Lane, 308 Georgia 10, that's a 2020 case. Butler v. State, 310 Georgia 892, that's a 2021 case. Stafford v. State, 312 Georgia 811, that's a 2021 case. All those cases deal with merely spilling the beans or recounting what occurred. It's not, those aren't considered statements designed to foster cohesiveness within the game, within a group. It's considered spilling the beans. And none of those types of statements in those cases.
Yeah, I think we talked about this before, but wouldn't this be statements made, you know, after the fact?
Well, that's exactly what
are they
spilling the beans is.
Okay.
And so there's a long line of cases.
And Mr. Steele pointed out, there's another case that came out about the spilling the beans issue, but I'll ask the state about that. So why wouldn't it be just spilling the beans, Ms. Hilton? I mean, because they're making Mr. Copeland and is Mr. Williams' sister Dolly Max are kind of just saying after the fact, basically, you know, making derogatory statements about the decedent. So or spilling the beans, as the defendants call it. So what other purpose would it go toward?
Your Honor, this isn't spilling the beans because again, their assertion is that Mr. Copeland is lying about the murder at all. And if he is telling the jurors that he's heard one of the defendants bragging about what he has done, and
So you're saying it's him bragging about the murder.
About the murder that he committed.
Wouldn't that be spilling the beans?
No, that's not him spilling beans. That is corroboration that the information that Copeland knew is corroborated by the fact that the individual who did it is now talking about, or at least ensuring the reputation of this gang amongst themselves, amongst the gang members, freely discussing and talking about what they did. The other co-conspirator, Dolly, or Miss Alexis Greer, is saying, this person better not play with my brother. That's what he's heard him say. That's what Mr. Copeland heard her say. So specifically, when they are alleging that Mr. Williams had nothing to do with this murder, he has no part in this murder, for his sister to say amongst the other co-conspirators, that nigga better not play with my brother after this, is not just spilling the beans. That is showing cohesiveness against this gang. And is keeping Copeland abreast of the gang's activities, which is always in furtherance of the gang, Your Honor.
Okay. Anybody else wish to be heard on this issue? Anyone? All right. As it pertains, what references in terms of video or audio, what are we going from?
This would be from 348.55 to 349.20.
Okay. All right. In looking at this particular conversation, the defense is related that it's hearsay, it falls under 401, we're not relevant, or 403, that is more prejudicial than probative. And they have also said that this is along the lines of cases of spilling the beans. The state has argued that the statements are in fact relevant. They're co-conspirator hearsay. And Mr. Copeland is talking about what he learned from Mr. Garlington. We've dealt with this issue before, but these particular statements that the court has heard from on page 389, lines 1 through 17, I'm in the court's in concurrence with the state in terms of it does not spill the beans. It does talk about the furtherance of criminal activity, the ensuring of reputation. It tells what purportedly the gang did, and the cohesiveness of the parties and the corroboration of info from Mr. Copeland So I'll let the jury consider that for what weight they want to give it. So I'll admit it over objection, defense counsels, and I will give you all a continuing objection as to that. And with that, I think that we're done for tonight, and we'll pick up with Mr. Adams tomorrow.
We have one more area
Yeah,
to
two
review,
more.
but we have no objections to those.
Which ones are those?
Defense counsel had page 396, and we think it's 396, line 21 through 397, line 11. And that's gonna be from 355.42 through
355.42 to what?
356.17,
356.
17.
Okay, so from 396 line 21 to 397 line 11, those are going to be omitted. Mr. Short or anybody else, do you have any further objections to that, sir? That's hearsay talk about Shannon and Dee shooting on Simpson.
Yes, I requested that, so.
Okay, anybody else wish to be heard about that issue? Okay,
And the last section, Your Honor, defense counsel asked for, I think Mr. Shar just put 398.
398, page 398, line 16.
Well, we have line 15 through page 399, line 13.
399, line 13.
No objection to that redaction. And the
Is
time,
that talk testimony about Thug taking choppers to get his necklace back? Is that
yes.
something
Your
like
Honor.
that?
Yes.
All right,
And the time stands at 3:57:05 to
350, hold on. Said 357:05.
yes, to 3:58:05.
Okay. Mr. Charter, anybody else, any further argument on that issue?
No, Your Honor.
Okay, all right. Okay, so tomorrow we will pick up with, as I mentioned earlier, Mr. Adams and his particular edits. Mr. Adams, it's conceivable that we won't work that long tomorrow, given the court's got some unrelated business I have to handle. So we more than likely will probably work from, I'm going to say, I'd like you all to report for 9:30 for anticipated 10 o'clock start time. We'll work a couple hours. I have a lunch meeting, and then more than likely that'll be the end of that particular business day. On the 26th, Wednesday, we will start 9:30 and work till probably around 1. No, and the court is keenly aware that we may or may not finish, Mr. Adams. So I will, we'll just do the best we can with that, and we will continue with that as appropriate. For your planning purposes, Monday, July the 1st, we will have the in-camera review of the transcript from the court's ex parte matter. So I will have you all upstairs in 8F, the lawyers, just the lawyers, okay, just for that. And I'll cover that with you all. Tuesday, we will go, that'll be probably, Mr. Adams, I'm going to say it's probably 9 o'clock. 9 o'clock. And then Tuesday, July the 2nd, we will go back to finishing up whatever we have. Mr. Adams, if you have not done, we'll be finishing that up, or we'll take some phone calls, the phone call issue. We'll start on that. Wednesday, July the 3rd, it's the court's intention to take up the show cause. I won't do that tomorrow. I'm going to take that up on Wednesday, July the 3rd, starting at 9 o'clock. Those parties have already been noticed. Okay?
What time on Tuesday, please, Judge?
Tuesday, it'll probably, you report for Tuesday the 2nd, 9:30 for anticipated 10 o'clock start time. And we should probably, that should probably be a full work day. Monday, Tuesday, and Wednesday should probably be pretty much full work days, okay? And then we're off the 4th and the 5th, and we'll come back on the 8th, and we'll see how things go. If on the 3rd, things are, or the 2nd, Mr. Adams, we're not done, or counsels with your redactions and or the phone calls, I may make some other decisions to include. We may, given the amount of video that we have and some other things, I may decide to bring our jurors back, but I'll make that call a little later on, okay? Questions?
Did I miss, or maybe the court didn't mention Thursday and Friday of this week between 7 and
Yeah, you
6?
missed that.
Okay.
Where you been?
I don't know where I was, but.
Are we coming to court Thursday and Friday, folks? Okay, all right. Why are you looking at Max? He's not gonna be, he's not gonna be here. No, we're not holding court those days, Mr. Matthews, at all. Okay, anybody else have any other questions? Mr. Steele?
On Monday, July 1,
Yes.
2024,
Yes.
when you called an in-camera meeting without Mr. Williams, Mr. Williams, through me, is invoking his right to be present under Article 1, Section 1, Paragraph 12 of the Georgia.
I understand that, and you can put that on the record. I'll bring your clients over, but given the fact that it is in camera, and we'll discuss issues of potential privilege, that is why you're, at least for that portion, as I mentioned, I will let you all be heard on that issue, and then you can share whatever issue that is with your clients. Okay, but I've heard your objection already. Okay. All right. Anybody else? Okay. All right. I'll see you all tomorrow morning. Okay. All right.
Thank you.